Okay. Yes.
Please.
Madam,
My Lordship, like to mention item number 104. 102, my Lordship.
Just wait. Just wait.
Item,
Just
item
wait.
number-
Just wait. You can't wait twice. Yes.
That lower court, the order of not to align it has been. The respondent has
What-
accepted the property is.
What do you want? What do you want?
Extinguished.
First after 2 weeks.
Next week it will.
No. Next 2 weeks.
Ships and the CCC, defense right without looking at the partner. No shipping of property lifted and charter location. Next to
2 weeks. Wait. Next.
CCC 221 of 2017 Lordship is coming for final hearing Lordship.
First after 2 weeks.
CCC and matter Lordship. Senior council is applied kindly next week hearing at your Lordship.
Which item?
No, it's a CCC at 2021.
First after 2 weeks.
CCC 2020.
My Lordship,
I have been filed. It should be the order.
2 weeks.
Someone said my lord companies in the next way, I go senior, but tomorrow they are.
What's that?
I don't know, 7 and 8.
Just wait. Just wait. Yes.
my Lordship, item number 102.
1 minute, sir. They'll call page wise. Have patience. Yes.
Page wise mentions page number 1, item number 1 to 13.
7 to 8. Company suddenly call me. Tomorrow they are. I told you.
Who else wanted it?
My family, my father.
Okay. When do you want?
Tomorrow they are. Every day.
Next Tuesday.
Next two.
It could not be compromised.
No, it had quoted 56, sir. The client had quoted 76.
Page number 2, item number 14 to 27.
Yeah, sir.
15 and 16 years, madam.
Just the respondent who may have it.
Informed understand? It was after 2 weeks. Yes, needed.
24.
Yes.
2 weeks.
2 weeks.
19 Lordship.
19.
Petitioner, one thing by.
Post after 2 weeks, right?
Item number 25, my lord. Petitioner advocate Mr. Surya Rao passed away. Your lordship, I am his daughter appearing on his behalf. Your lordship, I kindly pose the matter after 4 weeks to get the instructions, my lord.
Post after 4 weeks, right?
Oblige, your lordship.
Yes.
My Lordship, item number 102.
Page number 3, item number 28 to 42.
Post after 2 weeks, next.
Page number 4, item number 43 to 51.
45, 46, 47. For the respondent in this matter, from the other
45.
46 and 47. It all goes together, requesting it to be taken after 2 weeks.
Post after 2 weeks. Informed understand?
I wanted to.
Page number 5, item number 52 to 65. Page number 6,
What do you want? One or two?
My lordship,
What do you want?
my lordship, seeking 2 weeks time, my lordship. My senior colleague is suffering with a throat infection. So it is coming for final hearing. I am appearing for the petitioner in this matter, your lordship.
Most of it to the.
Much obliged.
Yeah, with this one. Yes.
Serial number 160.
Yes.
This is after the anti-cruise plan. In 5 minutes delay, I wanted a statement from the chairman's response. We kindly on board the daily history of
165 Kalata. 160?
5. 112, 113, and after 4, my lord. This matter of Yasi, my lord, senior counsel, Prabhu sir,
What's that? Item number?
112, 113, 114, lordship.
What do you want?
My lordship, I take up it. He was more in the daily list. Again, he was in the daily list.
Tomorrow it will come.
But he's retiring.
Tomorrow it will come. That's what it is.
Give you a pleasure.
Yes.
For admission, item number 1, A.K. Jayaprakash Rao, Nadir Khan.
What is that? Truth?
Account of the regulations for the respondent matter, 73 lakh worth of cotton base for.
He was on leave.
Pardon,
He was on leave.
what? As to the even there, the person going on leave, because the legal, I think it will be tenure of
No, fire accident has taken place when he was on leave.
yes, violence, but the allegation is that he can't get the policy renewed. On account of that, there are 90 you are actually finding him, but it's actually that.
On what ground he has interfered?
He said,
On what legal ground? Learned single judge has interfered with orders of removal.
that he has put in plain record of the past conduct of policy.
What is the apex court judgment? Learned single judge is referring to. What is it apex court judgment he is referring to?
He is referring to that there was some discrimination in respect of imposing correction to the employee.
What happened to other persons who were?
For that, he has resigned and left the service. Yeah.
The charge memo you have issued against 3 persons. Disciplinary proceedings have been initiated against 3 persons.
Yes, sir.
What kind of punishment you have imposed on other 2 persons?
Sir, what person has left the service, sir? He resigned.
He resigned and you have accepted that resignation. When disciplinary proceedings are pending, why did you accept that resignation? Forget about all those things. Please answer that. Well,
Explain the effect of starting this new last.
correct, sir. Identical charge was also leveled on the some other employee. You allowed him to go scot free by rendering resignation. Correct? Why did you accept that resignation when disciplinary proceedings are pending? Next employee, what is it you have action you have taken? What is the next action you have taken?
The next employee,
Oh.
but instead of infection, copies of increments, immediately.
Then we must apply uniformly.
My only submission to Dr. Karan, what 50% of back wages,
Higher officials were let off. No? Higher officials were let off.
entire officer, Karan, there.
Base 16,
Yes,
base 16 of are of 4.2. Read, sir.
yes. He further contended that the respondent corporation leveled the very same charges against GL Masale and the superior authority imposed minor punishment against him, whereas the respondent to impose a major punishment against the petitioner. Removal from the meeting was proportionate and clear discrimination while the board in the constitution.
Correct. Yes. Now back to para 5, page 19.
Consider the reverse submission made by the respective parties and after provision of the material available on record, the following point arise for consideration. Whether the include of punishment possible respondent or even the petition service is in accordance with law. Whether the petitioner is entitled to the belief in starting the expedition.
So there is no direction to reinstate. So now that we are
Right, that's it.
correct.
50% of back wages.
What 50%? Yeah, wait. On the ground of discrimination and proper, 1 minute, just listen. First listen, then you can argue in a better way. Senior. Single judges interfere on 2 grounds. One on the ground of discrimination, second is it is shockingly disproportionate. Right? It is a fairly well considered proposition of law. The punishment can interfere the ground of discrimination and proportionality. Then it's single judge felt it is shockingly disproportionate. What to do then?
Back next picture, they own telephone and they said they were going to seek time.
Notice before admission, chapter 2 is there. It is the second round of litigation, I think.
Yes, sir. Second round.
Earlier, 1 minute, earlier, appellate authority was directed to examine the case
Yes, sir.
on par with others and pass appropriate orders. In spite of that, you don't do that. Please.
Passing the order, sir. It is challenging.
Oh.
The next reason is,
Huh?
after appellate party considered,
No, sir. Earlier, removal order was challenged.
yes, sir.
This court disposed of having faith in you, saying that examine the case on the ground of discrimination and proportionality. You don't rectify yourself. Again, you pass the same order.
One order is strengthened, but Lemon Singh did not interfere. Only appellate authority order. He said,
Yes.
you have to consider the.
Para 9, sir. Para 9. Yeah, earlier filed with petition number 16582. Thinking that you will do some justice. You don't do that. Again, you don't rectify yourself. Again, impose the very same punishment. Correct?
Article 5, page 74.
If you argue further, we'll have to make 100% back wages. Yes. Earlier occasion, writ petition was disposed of by this court,
Yes,
remanding the matter to the appellate authority to examine the case of the petitioner in terms of similar punishments. That's one lesser punishment was awarded to such to other individuals who are higher in position. Correct? You don't. Once again, appellate authority, in spite of this court passing such an order, says no, will not carry your high court order. It is.
even reasons,
What reasons? When this court has deposed,
reason,
what reasons?
similar, Identical charges, they are not similar. That is the finding given by the update card.
Take a call 100%, get ready for 100%. Yes, call the line.
Item number 2, Abhaka Chikru, Winter Energy, KDSB.
Similar manner, the port number paper, key statements about four.
Yes, sir.
The matters are listed before here, they are mentioned about four lotteries. One matter,
What is the case?
it is page number 46.
What is the case?
Disqualification, JLM post, the lordship has passed, order than repetition. Remains still here.
What's wrong with it? What is the number?
468. It up to number 468, you got 20.
First along with first aid for some other page.
But
468 up to 2020.
Item number 3, Gadi Praveen Kumar.
Also, I just go down 1 second. Is it corrected now? 14329 of 2023 and 14329 of 2023.
dated 2/11/23, my lords.
What's same order mean?
Item number 3 also.
What?
3 and 4 I appear.
Next.
Item number 5, Jagatpal Reddy, Kasi Reddy, Kalturu Pavan Kumar.
Next Tuesday.
Next, GP for appeals.
Declaration and recovery. But in that case, we build that into table. Unregistered and unregistered, they take a part of that. Two days degree. Platform was degree. And recovery position EP has in fact a copy of the EP standard.
You are appealing for?
Appearing for the dependency, the good pillar. Appellate here is government.
Again, next Friday. Yeah, item number 5.
What? Again, everyone. 111, I give all these. But declaration of the end. Declaration of the end. In the terms of poverty, I got worker for 90 rupees. But still can be the parts of. Based on academic of stage. Then is an part of it. Not only in the page 48 in the agreement of sales, translation in page 40. Impact. Not only in an unregistered and account of the interpol document. But the document.
Event ex parte.
Right?
You remain expert.
No, brother, we are not dependent. But the other dependents, 3 to 8, you remain expert.
Yes, you are clear number?
1 and 2, depend number 1 and 2. At the 11, para 3, you actually make any written statement for depend number 1 and 2 stating that the plaintiff has submitted an old ROR. We are the contesting parties, but on our behalf, we have all put before on our behalf.
What is the order you are seeking?
They have filed EP for execution, but stay of execution with.
How much is the delay?
111 days in the current. Declaration, recovery position and injunction. That initially sued for declaration and injunction, subsequently it is amended at recovery position.
In order notice, after 2 weeks we can consider.
But Lordship my guidance is the past appeal.
Appealing or automatic admission.
Automatically admitted, past appeal is nothing but a continuation. There are so many judgments of the episode, wherein the Sanskrit court is the law finding and law pending court, wherein Lordship has to analyze the entire pleadings, evidence and documents and records. So Lordship may kindly see page 50, interpolated document is table. Basic and inadmissible documents who cannot be degraded. Lordship may kindly see page 50, interpolated document, backdate the agreement of sale and mention mirror. Page 50 for movement, sir. Agreement of sale dated 25/3/2020, 1979. The stamp was written on 19/8/1979, and there is an interpolation of the date of the stamp, interpolation on the date of sale of the stamp.
Is the finding on the interpolation of date of the stamp?
19/8/1970.
What is the finding of the court?
Finding of the court.
Court finding. But Lordship may kindly see page 16 paragraph. Page 15 paragraph. As can be seen, para 9. In order to scale the plaintiff activity able to assist with page 15 para 9. It would even in the sale agreement. As can be seen from the sale agreement, was executed on 25/3/1979. Where the document is dated 19/4/1979. It seems that there is a correction on the date as 19/4/1979. Since it is an unregistered sale agreement, it will not create any right on anyone unless the plaintiff shows his title on the same or his position. But now, the finding you also may kindly see. Basing on 812 and 813 para 19. That is subsequently he executed the same in favor of the dependent number 3 to 9. Prashika said the crucial evidence as admitted to the trial court under equitable. And placing the burden on the defendant instead of the
Notice. Counsel for the benefit for the appellant is permitted to take those notice on the response. In fact, no, there is history of orders past twice. First additional district judge,
Come up.
in OS number 166 of 2014, 27th March 2020.
Who was the counsel who appeared for the government in the lower court? Who was the counsel who appeared for the government?
What happened? Is also mentioned that government, the assistant government has argued, is also mentioned in that.
No, when you don't file any document as to the exact allotment of the land to the sericulture department, where is the question?
It is not.
It is the finding of the court. No document has been filed.
It is not only
I hope you understand what the court is thinking, right?
that to
You have to file, right? It will be there.
But the onus of proof fifth and dependent and the plaintiff established.
So even at least if you have a document as a virtuous, state is a virtuous litigant. State is a virtuous litigant. Yes, state is a virtuous litigant. You cannot hide any document if you are possessing it.
The statement, we have to go back and the report is that we going to say that the department.
You understand what we are thinking.
Next.
Government lands cannot be thrown away to private individuals in districts for non-filing of documents. It is not government, it is state's property, land.
The proposition of that by the
You are not talking on the proposition of law. There's something beyond the proposition of law. It's state land. It is not government land. It is state's land.
Item number 9 to 11. A. Krishnam Raju, A. Lakshmi Narayana.
Last week I became in 709 of.
What is first case, serial number 9? 689.
Appeal is filed by page. It is a common order. Appeal, appeal 709 of 2022 is against the order passing the expedition, modifying the punishment imposed. As far as item number 9 is concerned, that is that we question the order of the appellate authority who passed the order. And that should be appealed. Against that we find the expedition. That expedition is. The main.
So 1 minute. First tell us what are the requirements in GF file? 23403 is against gratuity order, no?
I filed one petition.
One petition is filed by
Me. That is.
2314
And yes. In 3403 of 2016. This is the liquidation filed by the bank.
against gratuity or appellate authorities order. Then this petition is filed by him is 230 203
203
47 of 2014.
Yes.
What he was challenging in this?
Punishment of this.
Dismissal or removal?
Dismissal.
Date of dismissal is
I just give a small synopsis and additional documents. In fact, the honorable court called for it. There was a common order.
Yes.
That is the reason.
No, that's right. Against dismissal order is 16 8 2012. Appellate authority order is
Appellate authority order is 110/2013.
that is against orders of dismissal. Yes, preferred appeal that is 30
That is 110/2013.
110/2013. What is this appellate authority's order of gratuity? Appellate authority order.
Upholding the control of the case.
Yes. What is the appellate authority order dated?
Appellate authority order is 1/3/2016.
Controlling authority order
2012/2014.
2012. One more period, last. Yes, correct. What are these IS 1 and 2 and 3 of 2021 in the station number comes in? Yeah, further.
Oh, changing the name of the bank was merged with Canara Bank.
This is originally syndicate bank.
Yes. No, there is no such application for amendment. Yes, in my petition, I have heard.
Yes. Not that.
And we are arguing the case in the recovery 709 of simple relays. That only 2 lines my repetition in regard to the gratuity business as a consequence of modifying the punishment. So that is the reason I first advance my arguments into recovery 709.
Yes, sir. Has anybody given any synopsis kind of? Yes.
Yes, I have given my synopsis also. In the form of petition arguments.
Yes, sir.
For a take on the court. The charges levied. Etc. At the outset, my respective submission is. The order of the Lieutenant Single Judge. Is self-contradictory. I can demonstrate 2 minutes. That is the reason first I would like to read. What is the order of the Lieutenant Single Judge?
First legal submission is self-confident.
Yes.
Yes.
You lost me kindly. Okay. Page 12 of the.
Yes.
I'm reading from in view thereof. Internal page.
Para 2 of the judgment, you can see. Page 12 is
Para 10.
para.
Para 10.
Then your page numbers are not tallied.
That's all.
Internal page you are referring to?
Yes. 10 minutes.
10, yes. Yes.
And straightaway coming. In view thereof. This court can only go in question whether the inquiry has been properly conducted and whether the disciplinary authority has power to or the order of business.
1 minute, sir. Again. Internal page 12, para 10.
Yes.
Para 10 starts at internal page 11.
At page 11, I am reading from because order before.
Right, in view of, yes.
Yes. I was not interested.
Yeah, no, yes.
Sorry. There's only reproduction of the argument. Very good. In view thereof, this court can only go into whether the inquiry has been properly conducted and whether the disciplinary authority has power to call the order of business. All the grounds raised by the petitioner are with regard to the method of conducting the inquiry by the inquiry officer. The inquiry officer has followed the procedure as laid down under the regular fact. However, with regard to the evidence produced by the petitioner, that is the statements of the governments. They are considered by the investigation officer, but have been directly not negligible since they have been obtained after finding of the charge sheet. This finding of the investigation officer cannot be found fault with. Next para is very crucial for my contention. Another objection taken by the petitioner with regard to the
So,
inquiry.
para 10, last portion, single judge has supported it.
Yes. There is a contradiction between 11 and 12 also. I will just demonstrate. Another objection taken by the petitioner with regard to the inquiry is that all the transactions have been approved in security or checked with the staff. And customers thereof have not been examined in the district. And though the department inquiries were conducted in this all of them, they have been let off with minor analogy of stopping the one examination with cumulative effect.
Without cumulative.
without. This confusion with the petitioner has not been prevented by the respondent that it's for. Therefore, there appears to be a differential treatment between the petitioner and other employees as far as the transactions are concerned. The disciplinary authority also has not considered the petitioner that put in 33 years unpaid service while awarding the punishment of dismissal. Here also may just note the next few sentences are very crucial. If the bank had lost confidence in the employee, it would not have continued the petitioner in service. But instead of dismissal, it could have awarded the punishment of compulsory retirement. That is the observation of the Honorable Court. It appears to this court that the punishment awarded to the petitioner for the alleged irregularities is excessive. Particularly since the bank has not suffered any pecuniary losses because of the illicit irregularities committed by the petition. Then your lordship may see ultimately what is the order passed by the leadership. In view thereof, this court deems it fit and proper to modify the punishment of dismissal from the service to the punishment of stoppage of one intermediate. 2 lines before, the court observed that instead of dismissal, it would have been a compulsory retirement. With the last change in the 2 lines and ultimately modify the punishment.
Acha, when he has attained age of superannuation?
When he is 15. 15.
Please be specific, sir. When? 36.
At least 6 to 11 children in the same character. So while at the outset is submitted to the self-honoring previous.
We have understood.
Yes, sir. Then I'll make my submissions and. Yes. So regarding the nature of charges, he has debited certain amounts to various customers' accounts, relatives, or his relatives. Ultimately, it credited to relatives' accounts, daughter, nephew, his brother-in-law, under legal charges, he debited to the party and credited to his brother-in-law's account. And just
Whether those amounts were recovered or was very lost to the bank or not?
really it is going to a wrong account.
No, that is right. But ultimately has and suffered any loss in the process. 1 minute again, sir. We looked at it, senior. We looked at it. I stand, please take your seat now.
Yes, ma'am.
Then I can. This is the loss cost.
The lost
Where
call,
is the charge memo?
the charge. The charge number.
Has been extracted somewhere.
No, no, it's file, it means 106 to 125.
One not 62.
125. On page 107, it starts with.
Yes.
May I read you? That you have been working as assistant manager, Hyderabad government of ranks since 16/7/2007. Until you were placed in the suspension prior to proceedings.
No, we are not interested in that. Just know the charge, articles of charges.
In the matter of collecting first charge, excess service charges on certain loan accounts, excess civil charges, excess charges for adjusting the same to the outstanding unconnected debit balance in the SB account of Srimati A. Ramarala. He debited certain extra charges and pay with this particular account. The details of the amounts and everything you have been given, right?
No, towards from this charge sheet,
Yes.
his bank has suffered something and the statement will be. Ultimately, that matters for sale. What is the lot which has been costed? There's no cost.
The charge number 3 is that, I'm just only taking one off. At page 1.
Yes.
In the matter of fraudulent unauthorized debits made by you for the benefit of closed directors. You have made the following debit inputs in various accounts of customers and transfer the same to the account of your closed directors. Account name we have given the amount debited we have given. Narration we have given, and the transfer to the nature of relationship we have given. The narration, first item, then you go up. See these officer, that is the thing. Second item, it was transferred to Mr. Samsara's body, that overdraft account. Then item 3, it was transferred to pre-narration review. And item 4, taken to case supported for wrong with the brother-in-law petitioner. Fifth item, repair. Then 6th, we again to re-narration review. The next fifth, we lost the fifth, and number 7, on this 3 to re-narration review. Number 8, again narration. Number 9, re-narration. Number 10, re-narration. These are the directly.
This is charge 3.
Yes.
Right.
And the total amount involved was. Of course, we like the police complaint also, Miller. The police are not taken first. That is a matter of the card.
FIR is registered. Then every FIR has to be taken it to logical conclusion. There's a question of police not pursuing or something.
The search had got me back 5 times and asked for the records. All those people who were involved in the same very transactions, they have not given enough those documents. That apart, that
Then
is
what is that FIR it is closed?
correct, huh?
FIR is closed.
It was closed, accepted by the AM, that there is lack of evidence.
Where you have the document?
I find it, Lord. In fact, they report also made it. Several number of times were gone to the bank has charged us. Huh?
Okay,
They are not.
we hear.
That apart, if the proceedings against other officers also were supposed to be given to the
And
police.
the argument I want to say.
They are not taken out.
To my factor, in argument I mean, you are entitled. Yes.
Even under the charge number 5, you can see certain amounts have been transferred. These are unauthorized transactions between the accounts of customers to his family members. Charge number 5. There are huge amounts, lost.
Now, these are all things, where is the inquiry officer's report?
Yes.
Yes, it is. Yes, not count them guilty. The transactions. Yes, two transactions. Whatever is that.
189 to 260.
He has not pardoned.
Sir, there can't be an argument on sentence to sentence. Which one, sir?
Inquiry office 489 to 263. And we got to the charge number 3 Millar.
1 minute.
It's a very lengthy report. It's almost 75 pages.
Its findings are at 263.
In regard to the issue number 3 below, that.
Findings of the findings of the.
Yes, ma'am.
Travel.
Yes, ma'am.
Yes, next.
Can- The disciplinary authority, why he imposed the punishment?
Yes.
That is no question. Correct. What made him impose? It is 80,807.
Yes, sir.
Initially, he reproduced the charges and all that.
81 to 87, right, sir?
Yes,
Senior counsel,
sorry.
ఒకటి చెప్పండి, whether disciplinary authority has considered the fact that he has rendered 32 years of service, was it considered or not? అదొకటి అది ఎక్కడ నుంచి ఇచ్చారు?
Really, 6 that will conclude.
86, right?
In middle of it. It's all the reasons explained above.
Oh.
I am not convinced with the submissions made by the CSO and therefore I would give the charges. Various other contentions made by the CSO in no way we take the lapses imputed and the extent held to the administrator. The CSO has not imposed any extenuating factors to consider any modifications or alterations in the inquiry findings and my disagreement thereon. I also observed that the inquiring authority has come to the conclusion to charge against to the extent stated there, based on evidence both oral as well as documented accused in inquiry are not on any extraneous grounds. Therefore, I have come to the conclusion that these compulsory law held guilty the charges for the reason that while he was working at Ashton, they didn't Hyderabad Portland of rank since 2007 until he was placed into suspension. While order dated 9/12/2010, he abused his official system collected excess service charges and certain legal loans, excess civil charges, excess car ticket charges for rejecting the same to the outstanding unconnected debit balance in the FD account of certain parties in latent violation of banks lending norms. Fraudulent, unauthorized debits made for the benefit of his close relatives, namely daughter, nephew, wife, brother-in-law, and himself. He allowed whose debit balance in the account and thereby unduly accommodated the parties concerned. In the process, he colluded with outsiders, exhibited gross negligence, extended pecuniary benefits to his close relatives, with market intentions and suppressing of investments made by his close relatives, and tarnished the image of the bank by exposing the bank to likely financial loss of his benefit. The acts next.
They have understood, right? Last necessary. Now tell us only one thing.
Yes.
Whether this is a loan charge in his entire career or some previous record or something.
That is, I have not found any record, not he was charge sheeted.
Okay, loan charge.
I did not find any.
Any other argument?
So far as the punishment awarded to the other officers and staff who worked during the relevant time. You know, I hope
They were also facing cybercritical charges? No.
no, they are negligence. Because they believed him and they signed the watches and all that.
So disciplinary action was initiated against how many set of individuals?
Total 7 or
7.
I have filed the documents today.
Inquiry was conducted for all, same inquiry in respect of all or different?
Common inquiry.
So different charges, different.
Yes.
So there is no relevance at all, right? Don't forget about that, right? Next. Yes, we have understood.
The respondent has been
No.
contending there is a
Initiation of disciplinary action against others has no relevance in the present case because it's an independent inquiry, it's a different charge memo and charge level is held to be proved And there is no defense for this person also, right?
Yes.
You're right.
The nature of charges are such, you know,
Correct. It's a serious charge.
commercial bank.
Correct. Yes.
I would not probably have lost by reading the judgments and all that. But, yeah.
Judgment is in respect of what? For what purpose the judgment, sir? What is the legal point?
One is lot of confidence, then what would be the
Loss of confidence, judgment, you
that is 2012 one SCC for
2000?
12 one SCC for 42. I have given the parent numbers to my index in that so that that's.
One minute. There is divisional controller, Karnataka State Road Transport, same thing, sir.
Yes,
Para 25 to 33. Next,
State Bank of Brigadier and Jaipur. What is name Chen? Now, yeah,
40,
2011 4 SCC 5.
para 7 and 8.
And para 7 and 8, most relevant pillar.
Correct.
I can maybe to read para 8 pillar.
Yes.
Next 4, I'm sorry. In my internal page 18.
Yes.
Next,
Yes.
court is considering whether the punishment of termination of service imposed upon a bank employee is shockingly excessive or disproportionate to the gravity of the poor misconduct. The loss of confidence in the employee will be an important and relevant factor. When an unknown person comes to the bank and claims to be account holder of a long-inoperative account, and a bank employee who does not know such person instructs his colleague to transfer the account from government to operative category, contrary to the instructions regulating government accounts, without any kind of verification and accepts the money withdrawn from such person, gets a token and collects the amount on behalf of such person. The purpose of banking to such he enables such unknown person to withdraw the amount contemplating the banking procedures and ultimately it transpires to the person who claimed to the account holder was the imposter.
There is no facts, a legal point is stated.
So what we do? You could say that it has lost confidence in the employee consumption. A bank is justified in contending that not only the employees who are dishonest, but those who are guilty of gross negligence are not fit to continue itself. In fact, in this case, Millards, the amounts have gone to his relatives' accounts for that. Dishonest intelligence.
One minute. This court is also not suggesting that it should be continued. The question of continuing him at this point of time ruled out. So don't.
Right? Because at that particular point of time,
Correct.
that particular point of
You are
time,
right. Single judge would not have modified the punishment and substituted the punishment stoppage of one increment with cumulative effect. It 226 has no power to do that. We are with you.
otherwise the learned single judge observed Millard, it's a case for punishment of compulsory retirement.
That is what we are trying to explore, try to understand. That is what we are trying to explore. Remanding the matter to you to impose any other punishment like compulsory return. That we can do.
My respective submission in this case is concerned. I'm contending only for that aspect, only to say
Okay.
manifestly the order is devoid of merits.
You are right.
Only for that purpose I am,
No,
not for the purpose that in this case, the court would have been right if their punishment was imposed.
No,
I modified the punishment and the
Supreme Court have been time and again saying that it is not for the courts to substitute the punishment and we are not an appellate authority to modify the punishment. It is at best on these grounds, if the court feels that the punishment is shocking, disproportionate and disciplinary authority has not taken into account the fact that he has rendered 32 hours of service and it is a loan charge. On these factors, it should have been remanded to you to consider and pass appropriate orders. To that extent, we are in agreement with you.
Yes.
Sir. It is not for us to say.
This is not a case according to my attention,
That is,
that where the punishment of dismissal can be interfered because of the severity of.
we are not interfering, sir.
I'm not saying that. Even if the constitution says impose a punishment lesser than the dismissal.
We not also suggest that. What all we say is the fact that he has rendered 32 years of service and he has attained age of superannuation. It is for you to take a call because disciplinary authority admittedly, when it has passed this order in 2012, he has rendered 32 years of service. So that particular consideration was not there by the disciplinary authority about the completion of that many number of years of service, and this is a loan charge. So in a punishment, as per the regulations, the severest punishment is dismissal.
Yes.
So person who has rendered 10 years of service, you have no other option except to dismiss him from service for this kind of charges. Correct? But for a person who has rendered 30 years of service, then his case stands on a different footing. The fact that he has completed 30 years of service must be discussed by the disciplinary authority and pass appropriate orders. The question of reinstating him at this point of time ruled out because he has already attained the age of superannuation. These are the only factors court could have corrected it. That's what we feel. In principle, we are in agreement with you that single judge was not justified in modifying the punishment to that of stoppage of one increment, that too with cumulative effect.
Respecting submission. Now I understand what is possible.
That's the reason we made you to
Yes, sir.
order of dismissal. We asked this one specific question whether the disciplinary authority was aware that he has rendered 32 years of service.
On this context, I'll make only one submission.
Correct, please.
That is non-consideration of past service of 32 years and there is a service.
Whatever it is.
Yes, ma'am.
Yes.
That is. Here is a case where the useless formality theory will be applicable as well as honorable Supreme Court.
What is the formula which will be approved?
Useless formality.
Useless formality.
That is, the reason is, the reason is not. A case where an officer working in a commercial bank, by his facts, which are fully proved, established that
He is guilty of the crime.
computer fraud and acts of such dishonesty. The law laid out with the Honorable Supreme Court is that we have to be with iron hands, we have to deal with such cases.
A judgment we can.
That's a bit. Your Lordship may take the judgment just now I have with that. The Canara Bank versus DK Avasthi. Your Lordship from
One
case 44,
Yes.
internal case 44. Internal case.
1 minute, last one.
Yes, ma'am, I'm sorry. Canara Bank versus DK Avasthi. 2005, 6 SCC, 321.
Page 44.
Yes. These paragraphs, of course, I have not indicated in my cycle. Because
No.
these are in a different context. That is the reason I'm.
Para 70. Right.
Para 7. That's the only reason.
Yes.
What is known as maybe
Yes, sir.
useless formality theory and the received consideration of this score in MC Mehta versus Union of India. It was observed as under. Before we go into the final aspects of this contention, we would like to state that cases relating to breach of national justice will also occur where all facts are not admitted or are not or beyond dispute. In the context of those cases, there is considerable case law and literature as to whether relief can be refused even if the court thinks that the case of the applicant is not one of real substance, or that there is no substantial possibility of his success, or that the result will not be different, even if natural justice is followed. Source decisions there. The latest addition to this video is source case. held that there must be demonstrable beyond doubt that result would have been different. Like submission is in the context that in this context. Have also not discovered use of discretion in certain cases of breach of natural justice. The New Zealand court in McCarthy versus Grant, however, goes off way when it says that as in the case of bias, it is sufficient for the applicant to show that there is near likelihood, not certainty of prejudice. On the other hand, says that slight proof that the result would have different is sufficient. On the other side of the argument, we have, apart from Brady versus Baldwin, so also stating that there are always certain and shut cases and no absolute rule of proof of this can be laid out. Merits are not for the court, but for the authority to consider. Ekman has said that the useless formal is dangerous one and however inconvenient, natural justice must be followed. His lordship observed that convenience and justice are often not on similar terms. More recently, Lord Bingham has explicated the useless formal source of case by giving 6 reasons. See, a detailed and analytic criticism of the useless formality theory has been made much earlier in the natural justice substance or shadow by books at H. Proud of Canada, contending that Malok and Lynn were wrongly decided. Courts and others say that the court cannot prejudge what is to be decided by the decision-making authority. P. Smith says courts have not committed themselves to anyone, though discretion is always preferred. Wade says that while full-time writs may not be issued, a distinction has to be made according to the nature of the decision. Thus, in relation to cases other than those relating to admitted or indisputable facts, there is a considerable divergence of opinion whether the applicant can be compelled to prove that the outcome will be in his favor, or he has to prove a case of substance, or if he can prove a real likelihood of success, or if he is entitled to relief, even if there is some remote chance of success. We may, however, point out that even in cases where the facts are not all admitted or beyond dispute, there is a considerable unanimity that the courts can, in exercise of the discretion, refuse certiorari, prohibition, mandamus, or inaction, even though natural justice is not followed. We may also state that there is a another line of cases as in State Bank of Patiala versus Sharma, Rajendra Singh versus State of MP, that even in relation to statutory clauses requiring notice, a distinction is to be made between cases where the provision is intended for individuals and whereas a provision is intended to protect public interest. In the former case, it can be made while a certain latter cannot be. We do not propose to express any opinion on the correctness or otherwise of the useless formality and leave the matter for decision in an appropriate case in as much as in the case before us, admitted and indisputable facts show that grant of writ will be in vain, as pointed out by Chandra J. Next paragraph. As was observed by this court, we need not go into useless formality detail. In view of the fact that no prejudice has been shown, as we rightly pointed out by London Council of Appellate, unless failure of justice is citation, or that it does not mean public interest to be fair of other day, this court may refuse to grant relief to the employee consent. See, their indication of us, government of the noted that legal formulations cannot be divorced from the facts related to the case. Personal hearing was granted to the appellate government, though not described. In case, post-petition hearing can obligate the procedural deficiency of petition.
Yes. Yes, please.
It's to be noted that the detailed charge sheets were, of course, these are on facts. My respectful submission is once it is the case, it's proved without, even if it's the past record is positive for him. And if it is considered also, if you have to the law, either the but we have to deal with iron hands.
Correct.
So ultimately, what would be the result? For a moment, that we have not considered is for return. That itself will not give any kind of right to him, because ultimately the result should be not even I should take a decision for dismissal. As per the law, later on the Honorable Supreme Court, I have to dismiss such kind of persons from the service, and I have no other goal. That is the law.
We have understood your argument. Now, we just also allow us to formulate a small legal point so that we can argue in a better way.
Yes.
So, punishments are available right from dismissal to censure or whatever it is to the disciplinary authority. Removal is also a major penalty. And compulsory retirement is also a major penalty.
Yes.
So, in what circumstances will impose compulsory retirement? Please, just because a person who has rendered 30 years of service,
Yes.
then you must at least explore the possibility of imposing that punishment. So, some cases, no, you are right. There is a distinction between dismissal and removal. So, why is choosing the harshest of harsh punishment, ignoring removal? Somewhere it should be applied with swine versus. That's what we are trying. You got the point. I'm not saying that in all cases, wherever it is proved, dismissal is the only answer. No. If dismissal is the only answer, then why in the regulations there is a punishment of removal? Why there is a punishment of compulsory retirement? So these factors, you disciplinary authority must explore. Yes, this is a serious misconduct. No other punishment other than dismissal has to be awarded. Something like that. So that discussion is not there. Actually, the administrative law must give reasons why it's confining to only dismissal but not imposing any other punishment. Because administrative law is such a law. Over number of reasons must be given so that it should indicate the mind of the person who is looking into it.
Sir, para 28.
Yes. Yes.
Page 336. In Omkar versus Union of India,
Yes.
Para 25, yes, page 47.
under that 28 is extracted.
Yeah.
That is what is the court intending now? The mind which this court has expressed. You can read that at para 28.
In Omkar versus Union of India, right?
Omkar, page 47 of.
Yes.
Principle originated in Asia in the 19th century, which has since been adopted in Germany, France, and other European countries. The European Court of Justice, for example, in the European Court of Human Rights, Strasbourg have applied the principle while judging the validity of administrative action. But even long before that, the Indians applied the principle of proportionality to legislative action since 1950. As stated in detail, by proportionality, we mean the question whether while regulating exercise of fundamental rights, the appropriate or least restrictive choice of measures has been made to the legislature or the administrator so as to achieve the object of the legislation or the purpose of the administrative order as the case may. Under the principle, the court will see that the legislature and the administrative authority maintain a proper balance between the adverse effects which the legislation or the administrative order may have on the rights, liberties, or interests of persons, keeping in mind the purpose which they were intended to serve. The legislature and the administrative authority are however given an area of solution or a range of choices, but as to whether the choice may infringe the rights excessively or not is for the court. That is what is meant by proportionality.
Administrative authority, they have a discretion of range of choices, which affects the rights of the individual.
Okay, we'll consider the next point. Yes, one minute, sir, just now you read para 17 is useless formality here, correct, sir?
My intention is to bring to lots of
Yes, sir, we have understood.
I want to drive it. Ultimate result would be the same because of the nature of the.
Correct, we have understood, sir.
Prove it. So it would become a futile exercise and it should not be only as a ritual that he has to go back. That is one. And secondly, when his conduct is proved such misconduct, then if the man was a century, it is a discretionary rate. So whether he deserves such kind of rate also has to be seen. And in this case, even there is any lapse on the part of the disciplinary authority, not considering the past unplayership record or past services, whatever he rendered, then the order will not become bad, or this court need not come to the rescue of the writ petitioner. That is the point what I want to drive it.
The next point we are writing like this. Charge is proved, the order of dismissal cannot be interfered, right?
No, it's not. Charges of such nature.
Correct. What is charge is proved, order of dismissal cannot be interfered, right? Yes, sir. First was self-contradictory. Third was useless formality theory. And this kind of charge is proved. Question of interfering with order of dismissal cannot be interfered, right? Yes, please. Next.
But therefore, only part. I would like to draw the attention to the display doctrines order last paragraph, because since we lost page 87.
Yes. 84. Chapter.
Page 87.
87. Yes, that's the order of dismissal.
Yes. No, the first, the preceding paragraph.
Yes.
The acts for which, yes.
Hmm.
I want to show that there is an application of mine on the.
Yes, yes.
P. Samasevara has been held guilty, constitutes misconduct within the meaning of regulation 31, that is the regulation 24, which invites imposition of appropriate penalty on him. Public servants and more so, the bank employees are required to be sincere and devoted towards the interest of the employer in discharge of their duties as they deal with public money held in trust. Sri V. Samasevara unauthorizedly, fraudulently collected excess service charges on jewel loans, housing loans, excess civil charges, excess RTGS from the customers, and credited a part of the charges so collected from the customers to set off debit balance in SP current account allowed by him and the accounts of his wife, daughter, close relatives, and thereby derive undue pecuniary benefit to self, others at a cost to the bank. Thus, he displayed absolute lack of integrity and acted in a manner which is prejudicial to the interest of the bank. Such employees have no right to continue in the bank. The bank has lost trust in him. Therefore, taking into consideration all the aspects and circumstances of the case, I pass the following law. South of that, he came out with reasons in the concluding paragraph.
Yes.
And so far as I have given somewhat judgments to that, I think about the scope of this. Not probably.
No, don't think like that, senior. Whatever you are entitled, you are entitled.
Judgment is a decent chapter, there is a process in India, created this way.
Which paragraph?
That is para 17 and 18 are below it.
Yes.
The next question. Yes, next question is whether the tribunal was justified in interpreting the punishment imposed to the disciplinary order. Constitutional bench of this court in state of Orissa versus Vidya Bhushan Mahapatra held that, having regard to the gravity of the established misconduct, The punishing authority had the power and jurisdiction to impose punishment. The penalty was not open to review with the High Court after 1956. The High Court reached a finding that there was some evidence to reach the conclusion which it became unaccessible. The officer of the governor who had jurisdiction and unrestricted power to determine the appropriate punishment was final. The High Court had no jurisdiction to direct the governor to review the penalty. It was further held that if the order was supported on any finding, that the substantial responded for which punishment can lawfully be imposed. It was not for the court to consider whether that ground alone would have weighed the authority in dismissing the public servant. The court had no jurisdiction in the findings government facing made out the case of respondent to direct the governor to reconsider the order of penalty. This view was reiterated in Union of India versus Sardar Bahadur. It is true that in Bhagat Ram versus State of the bench of two judges of this court, and holding that the High Court did not function as a court of appeal, concluded that when the finding was utterly valid, the court always interfered with the same. In that case, the finding was that the appellant was to supervise telling of the police which were not hammered march. Government had recommended the contractor the laws already by its telling of plea. Under those circumstances, this court felt that the finding it was perverse and unsupported by evidence. The ratio, therefore, is not an authority to conclude that in Indian case, the court criminal is empowered to interfere with the punishment imposed by Swami versus State of Tamil Nadu. The bench of the judges in this court, while considering the power to interfere with the order of punishment, held that this court, while exercising the jurisdiction in Article 136 of the Constitution, is empowered to alter or interfere with the penalty, and the tribunal had no power to execute its own discretion for that of the authority. It would seem that this court do not appear to have intended to lay down that in no case, a court or tribunal has the power to alter the penalty imposed in the discipline of the appellate authority. In that regard, para 18, next page. A review of the above legal position and establish that the disciplinary authority and an appeals appellate authority being fact finding authorities have exclusive power to consider the evidence with a view to maintain discipline. They are registered with the discretion to impose appropriate punishment, taking in view the magnitude and gravity of the incident. The High Court tribunal, exercising a power of judicial review, cannot normally substitute its own conclusion and penalty and impose some other penalty. If the punishment imposed by the disciplinary authority or the appellate authority shocks the conscience of the High Court tribunal, it would appropriately moderate either directing the disciplinary appellate authority to consider the penalty imposed or to shorten the litigation it made itself. In exceptional and rare cases, impose appropriate punishment imposed in the sense of part. There. In respect to the parity of punishment also, I have a one statement that is Lucknow Kshetri Gramin Bank versus Rajendra Singh. 2013, 12 SCC. I give that relevant paras. Parity of punishment is concerned, it has been dealt in para 17. And read only para 17 in the Kshetri Gramin Bank process.
So in BC Chaturvedi, the tribunal has modified the punishment to compulsory retirement. That was set aside.
Punishment in relation to it. The Lucknow Kshetri Gramina Bank versus Rajendra Singh. That is 2013, 12 SCC 372. I'll read only two paragraphs from the video.
92, 101.
92, it starts in that. 101.
Yes.
If there is a complete parity in two sets of cases, imposing different penalties would not be appropriate, as inflicting a higher penalty in one case would be discriminated and would amount to infraction of the doctrine of equality and stand out of political conscience. That is the ratio of Rajendra Yadav case already taken more above. On the other hand, if there is some difference penalty has been meted out, and what should be the quantum is to be left to the appellate authority. However, such a penalty should be commensurate with the responded. Penalty shall be disproportionate. As per the ratio of obligate case, even if the nature of misconduct committed by the two sets of employees is same, the conduct of one set of employees accepting the case and pleading for lenient to justify lesser punishment to them.
Such a case is not here. Nobody has pleaded that case that others were let off at time.
They are pleaded that.
So they have pleaded, but single page has not answered on that way.
No, it has been noted there.
Noted there, but special order was not set aside on the.
Yes, sir.
Then why?
But they will be arguing the case that is in just one taking a loss. Yes, the respondent will not leave that point. So.
Yes.
Even if the nature of this, then justify lesser punishment to them than the other employees who remain adopted the mode of denial. The result of charges to prove ultimately in the full-fledged inquiry conducted in that event, higher penalty can be imposed upon such an employee. It would follow that choosing to take a chance to contest the charges, such employees thereafter cannot fall back and say that the penalty in their cases cannot be more than the penalty which is imposed upon those employees who accepted the charges at the outset by tendering unconditional support. Then in para 19, I just read. The principles discussed above will be summed up and summarized as follows. When charges of misconduct is proved in an inquiry, quantum of punishment is imposed in the particular case is essentially the domain of the departmental authorities. The courts cannot assume the function of departmental authorities, cite the quantum of punishment and nature of penalty to be awarded, as this function is exclusively within the jurisdiction of the competent authority. Limited judicial review is available to interfere. With the punishment imposed by the disciplinary authority, only in cases where the penalty is found to be shocking to the conscience of the court. Even in such a case, when the punishment is set aside as shockingly disproportionate to the nature of charges claimed in the watch, the appropriate course of action is to vindicate the matter back to the disciplinary or the appellate authority with the direction to pass appropriate order of penalty. The court by itself cannot mandate as to what should be the penalty in such a case. The only exception to the principle stated in para 19.4 above would be in those cases where the co-delinquent is awarded lesser punishment by the disciplinary authority, even when the charges of misconduct were identical. It should be identical. Or the co-delinquent was registered with more serious charges. This would be on the doctrine of equality when it is found to the employee concerned and the co-delinquent are equally placed. However, there has to be a complete parity between the two, not only in respect of nature of charge, but subsequent conduct as well after the service of charge sheet in the two cases, the court delinquent accept the charges, including remorse, unqualified apology, lesser punishment to him would be justified. So in this case, my lord, the theory of discrimination cannot be applied because in fact, he is the beneficiary, misconduct. The others are negligent and careless and they have shown careless nature. And implicitly believed him and signed the vouchers and all that. For that, they cannot be found fault from the misconduct what is committed. Certainly, they are liable for punishment. Whatever punishment they deserve, they have been imposed to them also. I have filed the record also, serving on my friend about the, because they themselves.
You are a junior level officer. He was a junior level officer.
He is assistant manager.
Junior management grade one.
Yes.
First promotion.
Office.
Officer, first
Yes.
promotion. In a branch, he is assisting, he is only assistant manager, not manager.
Branch manager would be different.
In a higher post. Where he was working.
Yeah.
That,
as far as he is concerned, he is not the incumbent of the branch. He is only a statement.
disciplinary proceedings were also initiated against branch manager.
Yes, madam. Fine.
What is the identical charges they will attend you on that?
There are some record only we could get it out because these are very old charges. We have filed. You actually take the additional documents I have filed. Yes. The honorable court also asked.
Yes. Because first is some that you wrote. Squadron, next.
Case one is concerned that is irregularities coming to is on the overall. And lapses on the part of that is in the connection to this charges that the Washington get to case one itself. Lapses on the part of the 7 employees, what they are. We have a reduce letter number so and so along with investigation report in lapses observed on the part of the above officer employees. We have all marks from them. The above officer employees have since submitted their remark. The replies of the above employees are realized, vice versa, the lapses observed on the part in the table form. Copies of replies in the table forms are enclosed. It is proposed to bring the matter under minor penalties or mention should against the officers in serial number 126 above. M. Suri Prakash, senior manager, he is the branch manager. As a retired on superannuation on 31/2010, and he is a pensioner. Since the lapses on his part are not grave in nature and pension regulations, no action is proposed against him. The remaining 6 officers, they have taken actions on that, and the proceedings with actions of the court also, we have filed the other copies.
Yeah, bank is involved, all the employees.
No, but I think it stays.
7 employees plus 1.
Happens is when co-employee does something, then they cannot verify everything. They will simply sign alert. So it is not the involvement alert. It is certainly they were careless and negligent. No doubt about that. But that also we have. Yeah. Unless that fate is there and the co-employee, no function can be made. The involvement of other employees, they have been taken right by the petitioner and they were careless. But all these entries have been made by him only because we were computer based. Once he logged in and he entered these entries and all that.
Some is still functioning. That particular branch bank is still functioning.
Yes.
Okay, we'll consider.
Yes.
What is the gratuity case earlier?
Gratuity case is concerned a lot. Depends upon the result in this. The reason is, I just say few words. Because the ultimately, if my condition is accepted, the gratuity appeal has to be remanded. Here is the gratuity has to be remanded. We are simply raising the lordship example. The lordship may take internal page, para 14 of the common order, para 14 order.
Yes.
Para 14. WC number 22340 plan. Challenging the order of the third respondent of the authority. Refusing the appeal and back up to the order dated 2010 12 totally weekly application. Asked by the second respondent. And Prash has said the same way. The main ground of the petitioners in W324 is that first respondent employee has been dismissed from service and therefore as per the bank regulations, he was not eligible for claim for gratuity. It is submitted that both controlling authority as well as applied authority have disregarded this regulation and have allowed the application in directing the bank to pay the gratuity. However, if you have a judgment of this court on given date, in WP number modifying the order of punishment or dismissal to stoppage of unemployment, the cumulative effect of further holding that there was no pecuniary loss caused to the bank.
That is the question we are asking you since the moment you get your argument. One finding is recorded by single judge where there is no pecuniary loss caused to the bank. Is it correct or wrong? Other answer please.
It's not correct.
Once again, if he shows one single paisa loss on withdrawal. They have admitted before the controlling authority. They have not able to prove anything.
Where is the controlling authority?
Mischief. So one item.
It is not the way to argue, Mr. Pandit.
Technically saying the same thing, no?
Controlling authority, where is the statement recorded by the bank that there is no pecuniary loss? Where is controlling authority's order?
Controlling the date of appeal number 689.
689.
Yes, sir. Yeah, before I deal with it, I don't want to mix up both. The reason is, even for a moment assuming the law, he committed that misconduct and no financial loss is caused for a moment below. It doesn't mean the dismissal order will go automatically.
No, yeah, not.
What I
Sir, why we are asking this? Some reason for this.
But it is having that it is not that as if two things, whether he is entitled for the gratuity or not, it's a different aspect. Why I say this because the witness.
So, 1 minute, sir. We have prepared an appeal against single judge order. That portion of the petition where your petition is dismissed.
Yes.
So, advance some argument for that also. So that
At the outset, my submission is the learner signatures did not deal with any of my content.
correct, sir, we have understood.
Yes, that is one. So therefore, if other writ appeal is allowed, this writ appeal is to be also allowed by remanding the writ petition to the learner single judge for fresh consideration.
Come back to 92.
That is the order of the.
Yes.
It should be come to page 94. Answer to question number. Answer is merely because the punishment before the game is challenged with the High Court and it is pending. Effectively, that is the first. When it is answered by the applicant. That is for only for a calculation purpose, the issue number 2, I don't want to trouble your worship on that aspect.
Where is your regulation considered? Saying that regulation says,
I have filed my regulations.
no, how that authority has considered that argument of yours?
Not help me. My regulation, I have filed at phase 2 party level. Regulation 46. It says every officer shall be eligible for gratuity on the hour given when he is eligible. Termination of service in any other way except by way of punishment. So once the punishment is imposed, and the service is terminated, he is not eligible.
Which page is your regulation?
240. Yes. In the Act of Appeal number 689. Regulation 46. Every officer shall be eligible for gratuity of retirement, death, disablement, resignation, termination of service in any other way except by way of punishment. The completion of termination.
So regulation 240 was, page number 240 was not considered by
Yes, ma'am.
controlling authority or
Not
not?
as- I have filed my regulated.
The judgment of this honorable court, very single judge. It dealt with your same bank at page number 72. What do you say about that?
Giving under the payment of gratuity, yes. He is not eligible because there is a financial loss. Or
This assistant manager, was he trying to neutralize the accounts by transferring monies from one account to another account and showing it as if there was no transaction? It appears to be the modus operandi.
debited the amounts to certain customers' accounts.
Yes,
In the sense, he collected the charges.
yes.
Certain excess charges. But he allowed certain overdrafts or some customers.
Yes.
In some occasions, he credited these amounts, utilizing to those accounts. And in some cases, certain charges he credited to his relatives' accounts.
Which I have understood. Yes, please. Please.
I understand. But please take up my booklet 541.
has got all the paper composite filling. By reading out the charge sheet, my friend has projected that I'm a monster only to help the money, just by reading this paper. When your lordship asked last time for producing the disciplinary action proceedings initiated against the rest of the officers, initially they said, because the rank is by 0, we are not able to produce it. But then I have produced that. Then the lordship asked him to ascertain the correctness of that. There were 12 officers who were who handled the same very transactions, and out of them, 8 people were charge sheeted, not 7 like they said. 8 people were charge sheeted, and 1 person was censured.
Oh, 1 minute. The way it is allegation is in your case, you have transferred the amounts in your relatives' accounts.
And from
No, 1 minute. First listen, so that you can argue in a better way. Is there a similar allegation is leveled against some other officer also saying that he has transferred to his personal relatives account? అది ఉందా లేదా చెప్పండి.
even the transfer of the amounts to my accounts are the legal fee, not they were not yet proved. 5 and 6. Item number 5 and 6. He has said huge transactions in the account. He said. Then he said they were not proved. The other one is heavy transactions from the customer's accounts to my account. Inquiry officer said. 252, the finding that there were huge transactions in my account, the inquiry officer does not return a ruling on that. He says definitely there are certain unusual transactions in the accounts of the CSOA and his family members, but the CSOA submitted various explanations along with document evidence, including his wife's income tax returns. So the same are placed before the disciplinary authority for consideration.
Where you are reading 242?
In my bill,
Yes, yes.
page number 252, second paragraph.
250. Yes.
So he has not written the ruling, holding guilty or otherwise, and he has placed before the disciplinary authority.
Where you
Sir, definitely there are certain unusual transactions in the accounts of the CSOA and his family members, but the CSOA submitted various explanations along with documentary evidence. Same are placed before the disciplinary authority for consideration. And earlier also he said that he has filed his earlier income tax.
He has said that so and so charge is not proved and recurring.
Definitely, he has placed it for the disciplinary authority to decide on this.
No.
He was not able to give a ruling. He has not given it.
Who?
Inquiry I heard, right?
The job of inquiry officer is to give a specific finding whether charge is proved or not.
Yes, so he has not said it.
Charge is not proved and కూడా చెప్పలేదు కదండి ఇక్కడ.
రెండు చెప్పలేదండి.
మరి
they left it open, no? So it is for the disciplinary authority to decide. Other charges said the charge is proved to that he has affirmatively for all the charges he has for all the imputations.
Right.
Insofar as this is concerned, no? They said he has placed people the disciplinary authority to consider. No?
Correct, sir. Please, 1 minute. 262 is the final conclusions.
Yes.
Read.
About the huge transactions.
Not use transactions. Just read the conclusions, findings of inquiry officer.
Definitely there are certain unusual transactions in the accounts.
I think I will read. Page 262. Findings.
263. Charge is everything is coming under integrity, honesty,
Correct, sir.
that is charge proof.
1 minute, sir. I don't know. You can't ask a question to me, right, please? Please read at page 262. Findings are ready, sir.
Findings is proof.
They're in section, no?
And imputation has to be proved, then charge is
Correct.
proved.
According to you,
Listen, no?
In
There
according.
are about 8 imputations. Out of 8 imputations, 6
Forget about
imputations are
imputation.
proved.
How many articles of charges are there?
8.
8.
8.
Have you submitted your objections to these inquiry officers?
Yes, my lord.
Where is the objection you have taken? That each charge has to be finding has to be recorded. Please, Kunarami.
But whatever he has done in respect of those where he has.
1 minute. Please, page 251 once.
251.
You said issue number 4, right?
Yes.
So please read issue number 4. What is the imputation?
Whether the CSV made unusual.
Slowly. Let us read slow. Whether the
CSV
CSO
made
made
unusual transactions.
in the accounts of self and the account of his wife. Now, come to the conclusion.
Yes.
Definitely, there are unusual transactions in the accounts.
Yes.
When the question posed is imputation is whether there are any unusual transactions made. And if the finding is definitely there are unusual transactions, do you want anything more to be read in between the lines? No, I'm just asking you.
Like
Clear the court's mind.
8 imputations.
You are right, sir.
In one case-
1 minute, sir. We have understood your point. 8 articles of charges are there. So inquiry officer should give a specific finding for each charge. That charge is proved, not proved, or something.
Yes.
You can't just give a brief statement in the form of findings and say that charge is proved, right? That have you raised this objection to the inquiry officer's report is the question you are asking.
The submission should inquire on the report is raised.
Where is that objection you have to?
Oh, this one also that is 258 page number also. Another charge where actually has given a ruling.
Yeah,
Yes, I could not find any lapse at the bottom of the CSV in established set transactions.
Where
258.
250?
Page number 258 on item number 7.
Yes, read.
The item number 7, whether the CSV put through transfer of funds of for lakhs of rupees from customers' accounts to the account of the self and his family members, relatives' accounts at New Nalagunta branch, Hyderabad. Now the ruling is, as such, I could not find any lapse in the part of the CSV.
Charge 7 is not proved.
Not good. The other one, he has not given a ruling like this, but he said, I am placing it before the disciplinary. Now, the disciplinary.
We are not that fast, no. You have to write your argument. Charge 7 is not proved. So, we have understood you now.
Yes.
Have you raised any objections to the inquiry officer's report? Like the way he has given to charge 7? For each charge, he should have given such a finding and objection raised.
My only so basically that the inquiry was not properly held in accordance with the principles of natural justice, and I have given details. So in my arguments also, page and verse I have stated.
Objections, no, you said? Yes. To the inquiry officers, when you have submitted those objections?
Immediately, inquiry report was
State your policy, immediate marking.
24th July 12. Page number 263 to 272.
24th July
2012.
So what is the date of inquiry officer's report?
2nd June 2012.
2nd June.
2012.
When this report was furnished to you? Inviting objections from you. మీ రిప్లై ఎక్కడ ఉంది అది చెప్పండి
నా రిప్లై submission made and inquiry report is on 24/7 263 to 272.
When you have furnished the inquiry officer's report, when you have furnished the inquiry officer's report to
But in the inquiry report, each and every issue, like,
అయినా కేసు కదండి ఆయన ఆర్గ్యూ
I know.
The first charge here that I have collected unauthorizedly, excess service charges. First 5 pages of the charge sheet is only related to that one. Now, permit me to draw your Lordship's attention to page numbers 320 to 318 of my book.
Yes.
318 to 325. These are all the vouchers pertaining to the collection of the excess service charges. Huh? Now they say that I have collected this, I have authorized this at least 8 times. They have said in my charge sheet that I have done it. Huh? Now, if you kindly see these vouchers were authorized by the chief manager of the branch, not me.
Correct, but it was transferred to your relatives of.
No, not these amounts. No, not these amounts. Not these amounts. They say I have.
Do you admit at least one case that it was transferred to your near relatives accounts? Yes or no, Japan?
No, see, there's a lady who wanted to make a housing loan. She is the one of the staff members.
Who is Naresh? Who is your nephew?
Yes, Naresh is my nephew.
Thank you.
And the bank's panel advocate is one of my friends who worked in the bank, and he put in his papers in 2001 and started his practice. And he was requesting all the friends, he was a union leader and I was also in the same union, So he was requesting friends to give him work, So my nephew who was not employed, I got him with him employed because to do the running work to go to different registrar's offices, obtain CCs, ECs, search reports and all those things. So he was paying him. So the amounts were paid to the advocate through him. That advocate has came and told in the inquiry that I have received all the amounts. The bank has not paid them again. Amounts 7 times were paid to Mr. Naresh. All those amounts were either for towards CC, EC, etc., or the advocate's fees to be paid to the advocate only. And
So why you have to transfer that?
Because his account is there, not his account.
Why you are putting money in his account? That's a question.
He was working in that Ramreddy, that advocate was not having an account in that branch. So paid to him because he stays in Patel Nagar, this is his Boravada branch. So the amount has to be paid to him so that he can withdraw the amount immediately and go to the
advocate's fees or commission, I think.
No, it's not. The advocate himself has come to the inquiry. Advocate has told that.
No, panel advocate should
be. No, but the advocate was not paid for his services for his title search report.
Panel advocate should have said.
The bank has not paid again. No? Maybe you can say there was an irregularity in making the payment through him.
All this was not given in your letter dated 2/8/2011, which was given to the bank. That letter is there, addressed to the branch manager, Syndicate Bank, Gorabanda branch. Thank you, sir. Yours sincerely, V. Naresh. All this has not been stated. Page 279. It is a very small letter. You speak only nothing of what you are saying across now is stated in the letter. Yes, that's all.
Read letter number 280 also.
It is your whatever you are saying now about advocate and all, nothing is stated.
As far as Naresh's account is
nothing is stated. You should have told there that look, he doesn't have an account. I should have. That is yes.
Let me read this letter.
Very
280. I am having SBI account number also. This by Sevakoteswara, my brother-in-law, my wife's brother. I am having SBI account number also.
Writ appeal 709, page 279.
And the other
280.
278.
278 in your writ appeal.
280. Let us come. 227 to 280 is the letter.
Okay.
It's okay.
Right. Let me read this.
No, that has not relevance at all for the legal purpose. Right.
No.
What's your next argument?
They said that I have transferred 7 lakhs from my brother's account to my account. No, I required amount to be shown in my account for visa purpose of my daughter, who had gone 3 times. So for visa, 4th time she got it. So every time needed, this amount was transferred.
No problem, sir. You are accepting your argument. Yes, please proceed legally. Right.
No, these letters, when the charge sheet was given to me, and when these allegations were made, that I have transferred these amounts and misappropriated these amounts my brother-in-law second.
Sir, we are not appellate authority to hear all those things. Please proceed.
No, naturally, I'll go to the and ask them to give a clarification to the bank because the investigating officer, when he found that there was a transfer of amount from one account to my account,
We have understood, sir.
he should have gone to him and found out.
1 minute, sir. We have understood your argument that the inquiry officer, instead of holding each charge, dealing with each charge, has gave a finding that charge is true, right?
Yes, right.
And you have not raised the objection. What all you said is that 1 minute. You have not raised that specific objection. What you said is inquiry was not conducted as per the rules and with violation of principles of natural justice. There is a second argument.
Yes.
Raskoni. Yes, sir.
Then there was a transfer of fund from one account to my account.
We are not interested in that, whether it is transferred or not. That has no relevance for us. Legal argument.
What I'm saying is that inquiry is not, these statements were not taken on record and.
That's what we have noted.
He says I will treat them as scrap.
Correct.
Inquiry officer.
1 minute, sir.
Should he go into the content of the letter? Or should he go into the?
I don't know, sir.
These were given after the inquiry.
Yes, 1 minute, sir. We have taken your argument.
I need you to indulge Pilada because these were the wild charges made against me. When I receive a charge sheet, you have unauthorizedly have done it.
That
Naturally, I will go to the customer and request him to
1
clarify.
minute, sir. 1 minute. That covers your legal argument. Inquiry was not properly conducted and with violation of principles of natural justice. That will take care of legal position, right?
These letters are treated as scrap. He said that maybe.
Okay, couldn't that change?
I'll bring you.
Inquiry officer's report again to you.
All these letters, and his perverse reasoning is that these were given after the charge sheet was issued. The letters will come into effect only after the charge sheet is issued.
Where is that
In
finding?
the first place,
Where is that finding?
page number 237, 238. Page number 237, point number 3. The other line of the defense adopted was by producing the document DEX 1 to 10. At the outset, these documents deserve no consideration and should be treated as just scrap papers for the following reasons. Look at his perverse reasoning, Lord. I was given 15 days time to give a statement of defense. So immediately I went to these people to clarify to the bank directly.
Yes, objection whether you have raised in your objections.
Yes, in my very.
Which page are the 218 to 2? Are they current?
In the proceeding itself, it is there, Milada.
Where is your objection, CD? A letter 27, 24/7.
I did update, but whether I objected or not, Milada, if the inquiry officer not supposed to go into the letters. In the first place, it was for the investigating officer to have obtained these letters. He did not do his job. And when I asked him, did you contact those customers and find out whether the transaction genuine or not? I'm not obliged to contact them, he says.
Objection letter in the this shipment.
The third point, 265. I submit that a cursory glance at the charge sheet leveled against me and proceedings of the inquiry would reveal that the same is a result of assumption and presumptions. He automatically presumed that there was a mistake and fraud. And also based on misinformation and misunderstanding of the facts and circumstances of the case, the investigating officer, MW1, he was the only witness. The customers were not brought to the inquiry as witnesses. Had not bothered to discuss the matters with the material persons, that is the customers, account holders who are named in the charge sheet, the matter of the transactions and also failed to lay his hands in the most crucial data that is the document, the concerned vouchers, which were authorized by them. Page number 265, page number 3. Yeah, the paragraph.
What is the date of charge sheet? 27/7/2011.
And I was given only 15 days time. So before I submitted my report to the bank, I wanted the customers to clarify to the bank. And they given the letters directly to the bank. Nor were they brought to the inquiry as witnesses, if at all I had done any mistake. Because the investigating officer who took obtained those documents before he informed that there was a fraud. And when I asked him in the inquiry, can you see the proceedings also? I am not required. I am not obliged to. What kind of an investigation was the jealous office, the public secretary?
What does your regulation covers, how charge sheet has to be issued? List of documents, list of witnesses,
They were not given.
What does the regulation say about charge memo? List of witnesses, list of documents have to be furnished.
All the list of documents.
Immediately we are asking a question, no?
Regulations I have provided along with the citations.
Right. మీరు అవన్నీ ఆర్గ్యూ చేయరు మేము చెప్పిన పాయింట్ కి మళ్ళీ మాకే చెప్తా ఉంటారు కదా సరే
Along with the citations.
చెప్పండి ఎక్కడుంది
Page 124.
చార్జ్ షీట్ అది ఎక్కడుంది వేరే ఎగ్జాక్ట్
Regulation 6.
రెగ్యులేషన్ 6 దిగా
Procedure for the Rashtar.
పేజ్ నెంబర్ చెప్పండి సార్
Case 124. No order for imposing any of the major penalties specified in one of the schools. Regulation 4 shall be made except of the inquiries having it. Whenever the disciplinary authority is opinion that there are inquiry of any just shouting. Whenever the displayed are sub-regulation 2, regulation 6. Then whenever the displayed are is of opinion that there are grounds for inquiring into the truth of any implication of misconduct or misbehavior against an officer employee, it may itself inquire into or appoint any other person.
6(3) చదవండి సార్
Where it is proposed to hold an inquiry, the displayed are shall create distinct charges on the basis of the allegations in which the officer involved and the articles of charge together with the statement of allegations. List of documents relied on along with copy of such documents and list of witnesses along with copy of.
So it is a requirement. Where are the list of witnesses? Where are the list of documents?
Is not provided.
Then on that ground itself, it is liable to be.
There is no such plea that any witness was.
That goes to the root and deal.
So whereas insofar as the violation of any rule is concerned.
Even the state of the state. Right, on now of yourself. It's not like that. What is better? Make it this. Kind of. I'm not close, I'm not close, I'm not 6 feet. What are the wrong problems you're doing? What is?
Yes.
Okay. So like that, you're done. It's turned out to be like it's somebody in the place. Yeah, your name is that. Basically, takes part of the year like that. Okay, any other arguments?
Last point, let us go. Last time.
You don't go by the time and you go by your legal
I
argument.
have given it.
Like, all the time this could have been, but
Page number, because I am the, so, page number 315. 315,
Yes.
That is the debit slip signed by the branch manager to the debit of the miscellaneous income of the account by 10,000 rupees, which relates to refund of service charges on a housing loan. Because during a particular window period, the bank has announced that there will not be any service charges for people who have housing loans. And therefore, whoever has arrived and if you have collected, refund those amounts. Now they said that I have unauthorizedly without making slips, so refunded this amount. But this was signed by the branch manager, not me. Now, kindly come to page number 238. Look at the inquiry officer frustration on this slip.
Page number
238.
yes.
Page number 238, second paragraph. I will start from the middle of the paragraph. What the CSY sort, that is in the first paragraph, the management of Gorabanda branch has given a non-availability certificate regarding the slips pertaining to the transactions. As many as 38 slips were not available in the certificate branch has given. Now, there is a concurrent auditor in the branch who is supposed to see each and every transaction and certify at the end of the day that all transactions are genuine. Now, how so many slips will be missing? I was suspended from the branch. I had no access to the branch. And then the branch manager also at the end of the day, he will give a certificate that all the transactions are found in this slip bundle. Now they give a certificate. Now, some little bit lower in that regard. But the CSY sought a debit slip pertaining to miscellaneous income of rupees 40,000. In the same paragraph, 8th and 9th line. But the CSY, are we reading together?
Yes, sir.
But the CSY sought a debit slip pertaining to miscellaneous income of 40,000 dated 13/2/09 along with the office note attached to slip wide is letter dated 15/2000 in inquiry. Because I said the slips were made. The Borobanda branch was required to look for the slip and provide the same if the same is available by the inquiring authority, but is letter dated so and so. The branch should have simply done this, either providing the slip if the same is available or to issue a non-availability certificate if the same is not found. But strangely, the branch has not stopped with providing a non-availability certificate, but sent a Xerox copy of the slip for rupees 10,000, which is not at all asked for by the inquiring authority. By using the slip, the defense is trying to create an alibi that though the slips are available in the branch without verifying the slip bundles have given a certificate. If the slip which is made an allegation against me is there, the branch has given it. The inquiry officer is not able to hold me guilty because this slip is available. The branch has it. Now, if you come to the lower part of it, and he says there was some collusion, thus the motive behind the request for providing slip which is not connected to the charge sheet under inquiry from the side of the defense and providing a slip not asked for by the branch indicates that CSY and some staff members of the branch are hand in glove and got vested interest for the reasons best known to them. If so many slips are actually not available and all without a slip a transaction cannot take place in the bank and a slip can be handled by more than 2 people, not by a single person. The auditor was not considered against. It has given any wrong certificate. Such no
Yes, sir.
The most concerning part is that the excess collection charges I have talked about and the jewel loans. I was not in charge of the department, but
We cannot reappreciate the templates. I don't know why you're.
the chief manager has signed it. I have not signed it. But the allegation is that I have made it. No, they are using the word authorized in a very, very loose sense or without understanding its meaning. If I want to draw 5,000 rupees from a bank, I go and give a check to the bank by signing across the check. And the clerk across the counter will only enter it. The officer supervisors they
Argue legal argument.
They are not authorizing it.
Project the case in a legal.
Similarly, the OHS are authorized by the chief manager.
We understood, right?
So if at all there is a mistake in this, then charge should be.
Yes, sir. Next.
No, he the journal entry was letter. No
Next legal point, sir. Next legal point.
I am only confining to facts. You can listen.
What is? How can you argue facts before High Court? What is?
How injustice was done to me because
we are not interested in all that. Right. Argue legally.
Okay, Miller.
Formulate a legal point and then present the case. That's all.
The process of no, so like I said, no, the proceedings of
dismissal అయిపోయిందండి. Next gratuity చెప్పండి 240.
This is very important, Milord. The one seeker and charge sheet. I will read the procedure which they have filed now, which is coming to my help. Already is there on the record, but it's further helping me. To Vamsikaran also, they are saying the same charges that you have unauthorizedly collected the excess service charges. Let me read out.
Not necessary, we have seen it. Next.
And then they say that there is sufficient proof to prove the charges against you. They said,
That we have understood that, right?
and then again they say that he has only told that the Vamsikaran.
Please, how do you overcome that?
If you have read it or not, I do not know. The SSR, because he was a senior officer in the bank, he is eligible to do these irregular transactions. Therefore, I have done it, and they accept the statement.
Please conclude in 5 minutes. Please conclude in 5 minutes.
How can I just do that?
What's happening? No question of anything. Legal point you point it, argument development.
No, it's Vamsi Krishna's charge sheet, they have imposed the punishment even when
It
it
is not raised in the writ petition, right? That is out of our.
We are doing something now, Milada.
That's the reason out of our query, we asked them to submit that
Yes,
additional papers. That was not your case one before single judge.
but these papers could have been given to the police after the FIR, they have not given it.
That we have
If they
asked,
given to the
that's a
police, who will-
repetition. That is a repetition, right? You have already said police case has been closed and it.
Madam, I have given my detailed arguments in writing, why the inquiry was not conducted properly. And why investigating officer.
Now argue the case in respect of that appellate authority's order. Where he has pointed out one regulation at page 240, saying that when a punishment is given, gratuity cannot be paid. What do you say about that?
So Supreme Court judgment is that there should be an FIR and he should be prosecuted, it should be convicted.
1 minute. This page number 240 of is recapitulated number. Number 668, 689. 240, like this code, 240 page number. Indicate bank officer service regulations 1979. 7. The gratuity, every officer shall be eligible for gratuity on retirement, death, disablement, rendering him unfit for further service, resignation after completing 10 years of service. Just look into that.
Section 14 of the PG Act says that I cannot have my own regulation, which is recommended to me. This is a bank's regulation. Section 14 says that I cannot have a regulation which is recommended to my interest, which is not in harmony with the gratuity act. PG Act.
Payment of gratuity actually.
So bank cannot have a regulation which.
But that argument was considered by the authorities.
All these arguments were placed before the letter single judge.
Adiponian desire, what is kind of argument? Whether the authorities have considered.
Yes, my lord. I did that. Page number 367, 361 of my labor committee controlling authority submission.
It was section 14 under that paper. Section 14, huh?
Yes, sir.
You don't have the book also, right?
I can have a more powerful.
He is relying on section 14 of the payment of gratuity law.
The act to override other enactments. The provisions of this act or any rule made thereunder shall have effect notwithstanding anything inconsistent therewith contained in any enactment other than this act or in any instrument or granted having effect by virtue of any enactment other than this act. So this prevails.
Prevails అంటే పనిష్మెంట్ ఉన్నప్పుడు ఇవ్వాలని ఎక్కడ ఉందండి సెక్షన్ లో సెక్షన్ 4 చదవండి పనిష్మెంట్ ఉన్నాక కూడా మీకు ఇవ్వాలని ఎక్కడ ఉంది
సెక్షన్ 4 వస్తే మళ్ళీ సుప్రీం కోర్టు జడ్జిమెంట్ అవుతుంది అందులోని దే షుడ్ బి లాస్ దే షుడ్ బి ఎఫ్ఐఆర్ అండ్ ఐ షుడ్ బి కన్విక్టెడ్ None of the things are.
Whatever is dismissed.
Yeah.
Dismissed employees also entitled in the which portion of this act is.
Even for dismissed employees, that was below.
Where are they choose and then they may argue a question in the until possibility. We are asking a question.
Then that was to deny a gratuity that can dismiss anybody.
I don't know what is the kind of argument.
That's it. Because there's no loss at all.
What is kind of reputation? When bank regulation is there, for dismiss the employee, gratuity cannot be paid. So but you must show this act where it says in spite of dismissal, you are entitled for. Hello.
Kindly, come page number 361 of the control of that is. 361 top
Is immediate appeal.
is of the
Who's 361 and
361 of my petition. No?
writ appeal.
5.1 that is. Started from 360 bottom. On the one hand, they say that he forfeited the entire gratuity amount. Bottom fourth line, or fifth line start. On the one hand, they say that he forfeited the entire gratuity amount because of acts involving moral turpitude. On the other hand, they say that for calculation of gratuity amount, the appeal filed by the applicant required to be disposed of, and that therefore the eligible amount would be calculated only after the disposal of the appeal. Yet, another plea taken by the bank was that the bank needed time to calculate the financial losses after the charge sheet was disposed of. These are self-contradictions indulged in the bank in an attempt to meekly explain the non-compliance of the provisions of the period. The plea taken by the respondent bank that the calculation of the financial losses charged to the bank would be done only after the applicant's appeal was disposed of by the appellate authority cannot be accepted at all. In fact, such a contention exposes the disciplinary action itself to question. This explanation suggests that the punishment of dismissal was imposed upon the applicant on 12/8/12 without assessing the financial losses. Do they mean that the punishment of dismissal was imposed by the disciplinary authority and its decision was confirmed with the appellate authority without assessing the financial losses? That if that is so, the punishment can itself be called into question as the punishment was imposed, presuming that there were going to be financial losses to the bank, but in fact, as proved in these proceedings and also accepted by the respondent bank, there were no financial losses at all. It gives me an impression the disciplinary authority, while determining the penalty of dismissal and the appellate authority while confirming the penalty of the dismissal, did not apply themselves to this crucial aspect of financial losses and acted mechanically in a perfunctory manner. These are the observations of the control committee. So both the appellate authority and disciplinary authority said in their proceedings that there were losses. Bank is expert to use the losses. And they say after 3 years, they sat in leisure and calculated the losses. Is it not a very crucial point to decide the punishment to find out whether there are any losses at all? If at all, what is the extent of the losses?
The Raghubabu case, Supreme Court, the payment of gratuity judgment is a case of Mr.
Ajay Babu,
Ajay Babu, right?
CG Ajay Babu versus Union Bank,
Was he, what is the punishment in that case?
dismissal.
then your argument is not, cannot be appealed. Then you
We are saying that on account of the conviction we have appealed. Our contention is that there is a financial loss, and to the extent of the financial loss, we can calculate the amount. That is under a separate provision under
where is
the.
the judgment Supreme Court which happened? Yeah, Babu. Okay, we'll consider it.
No, I think the losses for labor, sir. There are no losses at all in the bank. And to the controlling of that, they said that there were 2 lakhs losses. Before when they filed the FIR, I have misappropriated 14 lakhs. Not a single paisa was fraud.
We'll consider it.
And even the 2 lakhs was also declared. And other amounts which they have said, 1 lakh are the refund of these service charges on the housing loans.
They go to take it in 2018. Minus.
One small point I want to add because page number 317, this one.
Not there, sir.
Single point, sir. Yes, sir, I have allowed huge debit balances in the account. My friend has said, 317. Now it is a check for 3,348 rupees.
Right, we'll consider it.
No, no, the debit balance was allowed by the branch manager.
We have seen that, we have noted down.
Then,
Right.
I'm trying to follow.
Yes, we'll consider. Yes.
Mirror, for any clarification, my arguments may also be candidate. They are very brief arguments with page number cycle, no?
Item number 12, Mamadi Avinash Reddy, AVS Lakshmi.
One last point, no? The learned single judge has observed that the documents, in rejecting the documents, the inquiry officer was right, no? After hearing it, let take from them. We are whether you agree with that observation.
You have argued, but must leave the case there.
No,
Yeah, this otherwise
very irrational.
1 minute. This kind of argument will continuously go on. You have heard, from past.
The signature's observation that the documents were not accepted, he was right in not accepting the document is not correct, because they are coming to my defense.
You have not filed any appeal against that observation, so what's the point?
My friend, in the appeal is charging as well. Oh, you have filed appeal before this. In a signature.
You have filed appeal against,
Signature observation.
you have preferred appeal against,
Signature's observation that in not accepting my documents, the inquiring authority was right. And he has done the inquiry in accordance with procedure later on, she said. Whether that observation are you not accepting that? Because they are the crucial documents for me.
so what you have, your appeal, okay, sorry, you are agreed by what order you have filed this writ appeal? Yeah, your writ appeal is agreed by what?
The punishment.
Punishment, because for other officers.
Should have been a reinstatement rather than.
And also gold medal. And also gold medal, you want gold medal also?
For other officers, they have stopped one agreement.
No, no, let us see your writ appeal. What is the prayer in the writ appeal? To modify the orders of single judge, of imposing stoppage of one increment with cumulative effect to without cumulative effect, right? Yes. And you want increments also. So order for payment of full eligible pension, including 10% computed. Order payment of all other consequential benefits as permissible. To pay gratuity as directed by. Okay. Yes.
Item number 12, Mahmood Avinash Reddy, AV.
Hospital services, same.
Yes. Government leader was directly filed in April. What is the status of the contractor in the Nilofer? Because one of the allegations is that Nilofer, I also have a contract for the Nilofer. They filed in April with page. Because one of the specific allegations made by the government. That I have another contract, and that is one of the reasons for allowing the release. Affidavit which they have filed.
I think you have to begin from the beginning. We'll have to answer the case from the beginning.
Sorry. The writer is the respondent in the notification. The tender notification may be put at page 120, dated 9/7/2022. 9/7/2022. Inviting tenders. Integrated hospital facility service. Page 124 of the tender document. Integrated hospital facility management services. The date of submission of the bid.
Tender notification is page, it starts at page
120. Section 1 at page 124 and 128 is the schedule of dates of the tender items. Bid notice is dated 9/7/2022.
What makes it?
Page 128. Opening of the bid is on 18/7/2022.
Integrated hospital facility management services.
Hospital facility management services. Which includes sanitation services, pest control, security services, patient data.
Yes. What is 128, sir?
Page 128 is the date of the tender schedule. Disbursement for this tender, I was awarded the contract. Proceeding dated 28/7/2022.
For a period of how many years, sir?
3 years.
That is work order.
Yeah, my work order is right.
28/7 is agreement.
Yes.
Huh?
Yes.
You were successful.
I have been a successful bidder and I have been awarded the contract.
Correct. What is the case of
The case of
petitioner?
the case of the respondent, that is the petitioner is that I have violated the terms and conditions of the tender. Since I am disqualified, since I am already holding a one more tender in terms of the tender. May I just draw your attention to the tender specification again. At page.
Yes, sir. Or prepare a small synopsis, it would be better.
120.
Prepare a small synopsis, it would be better.
130.
Next, we have to what?
It's subject. Next week would be another.
Next Wednesday. You are appearing in this case.
So, sir, savings that works. Let's online API.
Explain, then we have to. Yes.
Let's
Team Chief of the Services, one, Mohammed Ajmal Anwar.
the technical record. But on BTT, intercepted one Bolero vehicle which is carrying illegal timber. If the driver of rupees 26,000.
Constable, home guard, same thing.
Constable, the findings of the learned judge is contrary to the record. That's what I'm pointing out. You wrote me kindly go to page 7. Page 13 of the judgment, para 6.
Yes.
There are right heard the learns also critiquing response. It is to be noted that PWR is the owner of the jeep. In his statement categorically stated that the home guard who was with other constable warned me, do not tell this matter anymore. In fact, last time they entered the report showing that which PWR not stated that. In fact, PWR stated that it's dismissed employee himself warned him not to tell this matter to anyone. The report is started page 43. I also shown to you also it's not the statement for research. PW1 is the owner of the vehicle, PW3 is the driver.
Oh, why you have heard it a bit?
Also sought for to read the period of suspension as on duty that was not granted. To that extent, I have heard it.
Type of order is very difficult to sustain because courts cannot sit as an appellate authority. When the you set aside this order, you remind the matter. Because I can understand. Courts can interfere on the ground of proportionality. But there is no such discussion in the judgment, except saying that he should be reinstated and lesser punishment should be imposed. That's all.
If you watch so public. Where the article of charge is there.
Whatever it is. Courts cannot reappreciate their judges.
It's not a case of reappreciation.
And that too, incorrect appreciation of rules. Because contrary to record, he says it is home guard who said, no, actually it is other way around. No. So we'll have to set aside this order. If you want, we'll remind the matter to hear the case strictly in the legal standards.
So far, my humble submission is too bad. It's not a case of appreciation or reputation of it. But it's a case of murder. But the charge is that the respondent has collected 6,000 rupees and has put 10,000 rupees in the pocket of the
Home guard.
And then he has kept the vehicle which was containing the illegal people.
Correct.
But that 10,000 rupees was not recovered, nor the illegal input was recovered, nor this vehicle was seized, nor any other action was taken against the vehicle owner. Though the owner of the vehicle, driver of the vehicle they were examined, but nothing was seized. Like to prove the basis, which they say that I have collected 26,000 and have put 10,000 in the pocket of the home guard, then it is but necessary for the.
Sir, 1 minute, to remember that 1 minute, sir. Inquiry officer has conducted the inquiry.
Yes.
And the charge as proved.
Yes.
Now, can a single judge or under 226 court, can it give a finding saying that charges could not be proved? As though we are sitting in an appellate authority or the disciplinary authority or inquiry. Can we reappreciate the question? Because interference in disciplinary proceedings, the scope of high courts or tribunals is very, very, very limited. On the ground of principles of natural justice, violation of natural justice, that also we can't substitute the punishment. Correct? At best, pointing out these lacunas, we must remind the matter back to the authority. Or if the punishment is shockingly disproportionate, because everything there's a scale. Suppose somebody has done some minor misconduct or coming late to the office. You can't impose a punishment of dismissal from service. Then we can say, for such a small punishment, allegation,
Yes.
you are imposing such a major penalty of dismissal, this is shockingly disproportionate. We'll set aside this. Then also we can't set aside.
Yeah.
We have to remand the matter saying that, Baba, whatever punishment you have imposed is shockingly disproportionate. Try to reconsider the case. It's an observation. We can observe saying that punishment is shockingly disproportionate. Matter is remanded to the disciplinary authority to impose any other lesser punishment other than remote dismissal. That observation we can do. Otherwise, we cannot sit as an appellate authority. Let's set aside this. No. Let's set aside this. No, come back to page 15. Para 8, last sentence. Moreover, there is a delay of 3 days in reporting the alleged incident to the higher ups, but the delay is not explained in any manner. These circumstances clearly goes to show that there is no substantiation and reliability in the reliability of the statements of the witnesses. As such, it can be concluded that the charge could not be proved. All those things, it is not the job of High Court. Else we have
To the disciplinary authority, but the basic, but the evidence has not been based on the court. That amount of rupees that.
what we had said.
Yes.
This is appellate court. What something if it is there before a single judge, then we would have. But it is that observations are not there.
But the basics for that matter, I was punished, the inquiry was initiated, that amount has not been recovered. But this goes to show that. But what precluded the authority to take any action against the illegal timber? A person is, when a person is carrying an illegal timber.
What you were saying something that this is contrary to record.
Hiroshima kindly said the judge is that he accepted 26,000 net of the vehicle. He pertained so far as signal misconduct of the petitioner. That is established by the witness unit page 43 the inquiry report. Page 44 onwards. VW1 is the owner of the vehicle. Yes, page 44. Read that he is resident of so-and-so village of Tinur Mandal, taking livelihood as LIC agent on the night of 10/7 2000, he along with his driver went to so-and-so village of loaded sofa set and neem tree wood in his Bolero vehicle bearing number so-and-so. They proceeded to his village via Chennur. While they reached near Gerald petrol pump, Chennur, it was 2 hours. On 11/7/2012, on seeing his vehicle, the police person stopped his vehicle and checked the vehicle. On finding the tea wood in his vehicle, Abdul picked his snapped vehicle keys and asked him to put the vehicle to the PS. Then he took Abdul PC to Civil and gave 26,000, pleading him to leave the vehicle. After accepting the same amount, Abdul PC left the vehicle and also Abdul PC threatened him not to disclose the matter to anybody. In this regard, Inspector of Police Chennur recorded his statement, DSP Masarado recorded his statement. Then his cross-examination, what you may say. The only question is that if you want to proceed to Gundagami village from Sirsa village where Telangana Telestat in Chennur, you have to go via so-and-so village, which is far from the petrol pump. Hence, you have not visited the petrol pump on that day. He has replied, we left Sirsa village so-and-so. We entered to bypass road near Jala Tolong, Chennur, and then proceeded to so-and-so. Not even that he has not demanded, right? Not even registered. The next is driver.
The witness spoke against him.
Yes. Cross-examination shows not even put a suggestion that I have not accepted, asked for money, not received anything. The driver's community is not even cross-examined. So far, the home guard is also examined. And 4 and 5 subsequent witnesses, inspector and DSP, cannot directly. Establish misconduct of accepting. Nothing more is required. Such a case.
What's your name?
Mohammed Ajmal. That he was recruited into.
We can't even remand the case back to single judge. That's a difficult. Written in a sugar.
He has been recruited into. But he has completed 1 year of service without any clearance. This aspect has never been taken in. Your lordship to kindly say, the basic evidence.
What way it says? In the inquiry, witnesses came and spoke against you.
Yes,
Okay?
but what is the basis for that statement? These are the persons. One is the driver of the vehicle.
No, what is your case? That they have, with some prejudice, they came and deposed against you?
Yes.
Is it anywhere bias?
Yes, bias I have pleaded.
Where
This.
where in the
Inspector.
no, what are your grounds of attack of dismissal order?
Yeah, but.
Let us see your affidavit.
Yes.
Where is this affidavit?
Page number 46.
It starts at page 18.
Mine. But because the single judge will not have filed an additional affidavit. Initially, will not, it was not taken, this note was not taken. I have filed an additional affidavit for the right single judge that was not filed and not taken. So the single judge I have filed this one.
Is it WTR?
No, this is a regular petition.
So he says,
2018 petition.
no, 2016.
16 petition.
No, he says the challenge is by way of a OA.
Yes, Madam.
What are they?
Initially, I have filed an OA. That tribunal was abolished. Thereafter, it was transferred to this one.
Then it should be back.
The situation was also.
This is a fraud.
No, it's not a lot.
1 minute. The OA which you have filed,
Yes,
you'll have to pursue that case, not this one.
that was also remanded. It is transferred to this army.
Then argue that case.
This.
The transfer
Because
case
back when
was rejected.
yes,
Was dismissed and only this case is taken up for consideration.
that should not rest. There's only one petition I have brought to the notice of the connection there. That matter was also tagged. That was closed.
Where?
No, that was closed prior to this whole of this case.
That was
How
closed.
can it be closed?
No, two cases are there, but
How can you file 2 cases first tell us?
in fact, he should not have filed this petition once it's pending. Because since he has already filed this petition, the PR was withdrawn.
When it was withdrawn, prior to this or after?
Prior to this. Prior to this.
With the liberty to file?
No, by the time this is already.
Already.
In fact, I vaguely remember, I don't exactly recollect, but an objection is taken.
That was not present because the petition was already there.
This is abuse of legal process.
Let the tribunal was abolition.
No,
The file was.
abolition, those cases will get transferred into here, no? There's a question of abolition.
Later on, what I, in the meantime, what I.
Show us that order copy,
I will play.
post after 2 weeks. Next. Both cases. Madam, item number 13 and 18.
80.
Item number 14, PV Krishnaya, Chipika Services 1.
Contract circular. Appointed in 2007. Then while she was working, she was doing immigration work.
Where they are it? Let's media people have come.
Yes, Milan, but the thing earlier, Raul Milan, that was all.
That one.
A related same. Related same thing is. That is, more aligned. Not eligible as perspective of the.
That aspect was considered earlier. Page number 31 to 33. Same thing, Milan, they are rejecting the so amount of contempt. They have no power at all without filing an appeal against the order. Page number 32, your last should consider all these arguments at once.
Where is it now rejection order after 33?
Rejection order, Milan, page number 40. Except 41 is relevant. There are 7. 41, page 7. Viewed by the CM memo dated 16/2/2018, the individual has approached the Honorable High Court and filed petition number so and requested to suspend the operation of the memo dated so. The Honorable High Court, in its order dated 3/1/2020, has disposed of the petition and directed the respondents to consider the case of the petitioner and engage her as lecturer in English in any of the existing vacancies for academic year 2021.
What are the rules at the?
CO3 was. Then CO3 was.
Where are the rules?
Type employees no rules, but page number 32, this aspect dealt with.
Both have been issued last wherein person will continuing on 21.
Where is it due? Where is it due?
Not filed. Actually not filed.
Krishna Garu, there is a judgment of Supreme Court. First time considering the reject case, we positive mandamus can be given. The judgment of children. First courts will give a direction to consider. In spite of that, again they reject. Then courts can give positive mandamus saying that you appoint them.
Yes,
Judgment. Where is the judgment?
Maybe. But in 2 3,
Like judgment. First, if court gives the direction to consider and they reject it, then second time courts can give positive mandamus.
Yes. Real was. Was open. Page 32 on.
32 dealt with entire GO3. I will read not to like that. Last paragraph.
Page 32.
Last paragraph, land council for the petition contended that the respondents have mechanically rejected the case of the petition on the ground that petition was not in service as on the cutoff date as per GORP number 3 dated 21/6/2014. He further contended that there are several vacancies of the lecturer in English and the case of the petition can be considered for appointment on contract basis as lecturer in English in any of the vacancies. Land ground pleader appealing for the respondents had contended that the respondent not considered the service of the candidates worked prior to 28/3/2014, and that the government had accorded permission to the first respondent to engage, continue contract faculty with effect from 4/6/2014 for the academic year 2014. We further contend that if there are vacancies, the case of the petitioner would be considered for the next academic year, subject to petitioner.
What is, this is your argument, no, sir. You said your case will be considered on the next academic year. What you are arguing before the court and what they are passing orders and మీరు చెప్పిన కంటెన్షన్ అట్లా తప్పై చెప్పండి. And it's not me. State quarters for us, but I am concerned. I'll dictate in the open court so that everybody can hear. No? And I'll not record any submissions which you have not made. All right? Why would I do that? Right?
Case for taking so much of contempt, these officers are following lower officers,
Statement తీసుకోండి పాత్ర.
Have the
Item
number 7.
70.
One, sir.
Speak slow.
So they're getting the notice or what, from the respondent and they get the adjournment. And the question is that from the past 8 months or what, which is coming to the admissions. Versus my humble submission is that they have given the misrepresentation before this.
Number?
45, 40, 45, 40, 47. This is Mehboob Nagar case for I have come from Mehboob Nagar. I kindly considered and put it tomorrow.
45, 46, 49, 14 level. Is it inconvenient? Tuesday.
Much of it. Item number 68 to that, but they responded when we requested to 15 level.
Yes. Good option. 63, 50 level, yes.
Remember, 48, you are requested and the first of 2 weeks.
What's up?
51, 51.
Yes. What's up? Next.
As to a matter, item number 14, PV Krishnaya, Chitika Services.
Management. Yeah, okay, until. So now. Here, madam.
Obviously, 2 minutes. We are helping you.
Yes, yes.
The contention is, sir, in spite of the directions at page 31 and 32, they are not considered. They are rejected.
They rejected.
That rejection, the order is at page.
For the separately, as it could appellate authority to the sovereign court, reject. Earlier order is very clear.
They don't give any reasons why they are not taking prior to 2014.
Yes, they are not given any reason.
Which is not posting at Hyderabad or Hidapalli, instead of Jagitya. So there was no vacancies, just find out that 2014 there was a policy, given free work.
Is it reflected in the order? Yes, sought for so and so, and for that reason it has been. Is it reflected in the order?
It's a particular, he stated that personal free is not eligible. So,
But you are giving some Jagityal and others. No? She sought there and you didn't want her to give her there.
other page, I think Jagitya.
There is a copy of DO 3.
Only replacing the year of they have, this will be in continuation from 28 to 2014.
The copies.
I will copy it. Last. Page from the last.
Judgment తీసుకెళ్తారు.
They are not having, they can say, no vehicles are available. On that ground, they can reject. Otherwise, it's not clear violation. Score not take not promote the content. This is the way of the officer.
But I think I have dealt for judgment, judgment. Courts first time will give direction to consider this case.
Yes.
If it is rejected, then second time positive mandamus has to be issued and the judgment will be. Otherwise, it goes on like this. Court will say, consider, you will reject. Consider, reject. It goes on like this. There has to be some
Declaration must be given.
Huh?
Second case declaration must be.
must be given. And the judgment will be.
Just case.
Otherwise, there is no point in just passing order. There are two. Yes, senior, ideal, ideal.
Regard to the millet, this proposition which you wrote.
Yes, it is there. I've seen.
Now it was this millet died from the one of the judgment. Where the first occasion it has been directed to consider. And that direction has been issued and the court has taken
Positive mandamus, the point.
the court has given the declaration, this
Positive mandamus can be given. Because there can't be a direction to promote. There can be only a direction to consider this case for promotion. Suppose
declaration has to be from the, that you want to be well aware. That declaration.
we are aware కాబట్టి అడుగుతున్నాం అది.
Declaration of law made by the court, finding equally millet inconsonant with the.
First next Tuesday. Yeah.
We have the recent judgment that even the parliament is not having any power for judgment rendered by the Supreme Court. That is the present law. And these officers will not pass.
Continuation of the list, item number 20, K Uday, Sri GPP Services 1. Yeah, Nemali Pramo.
Yes, what happened to it?
22, K Anantarao, GPP Services 1.
What's happened to it?
23, Srinivasarao Madiraju, Chintalpuri Lakshmi Kumari.
Is your other thing? What it has been said?
The payment of interest on the late payment.
What is the meaning? What is the order? It never appeared before the court.
Recently allotted in the law. Here, the
And request. Notice before admission, post after 2 weeks, counsel for the petition permitted to take out medical record. In 2016, for the first time, you are open with. ఏం కేసు చెప్పండి ఎందుకు అది కూడా కొట్టేస్తే అయిపోతుంది.
The case of petitioner was opted for warrant retirement in court. And here his pay has been enhanced to a particular level. But he has opted for VRS.
Huh?
He has opted for VRS, 120, along with around 170 people. Second one, just the right. Then, the pay has been paid, then what is really entitled to? Not the approach the time and faster payment of the amount and also interest related payment on the, for the amount. The subsequent to final of the issue, they are paid the entire benefit, but the interest point of the not the agri department for the big.
He was already granted MACP in 2000.
He was granted a CP. Then from 1,380, his phase of similar by saving payments and pension and order 11,970.
That is what is.
Yes, sir, it's contention. After 2013, it was given. 2014, they have paid the entire amount. Well, he approached it, but because there is a delay in the department because at the stage, there are 470 people who have taken one debt. While fixing the amount, there is some mistake occurred. They have rectified and paid the amount. They got the interest, not the liability. It's not intentional. They have said so in the contract before the time. They have cleared the entire amount within 1 year.
Petition is filed. Met with orders filed with the Central Administrative Treasurer in OA numbers 1484 of 2013, dated 25/6/2020.
paid in like it also into that. It's everything to write off.
Yes.
Twenty-four and twenty-five are adjourned, 26 K Uday Street, GP for agriculture.
You are also there, sir, you are going away. Case no will now.
The WPTR itself is was because of.
They are becoming infected, yes. Conflict for the petitioner has informed the court. If the petition has become infected, you know, the same petition is dismissed as infant. Item number 26. Sorry.
27 G Ravi Mohan, GP for home.
Okay. Yes, sir.
For implementation of the order not in way 1791 of 2010 year on. Facts are like this year on.
Yes.
Lord, the petitioner, Lord, he was a constable or appointed in the year 1972. Lord, he was dismissed from service by an order dated 8/10/1986. Appeal was rejected. Lord, he filed an RP of 1989 by Lord before the APA. Lord, that was allowed by an order dated 23/4/1992. Lord, reinstating the petitioner to service. Lord, without back wages and a reduction of pay by 2 incremental stages. But that is there, Your Lordship. Lord, I was reinstated to service in the year 1992, Lord, in persons of the orders of the APA. But however, Lord, my fixation of pay was not done by treating my services as continuous. Lord, they have not counted my service from the date of dismissal till the date of reinstatement, or that is the grievance, Lord.
When you are reinstated,
Lord, 27/1992.
27,
1992.
27, what?
20 year, 207/1992.
You are reinstated.
Yes, I have been
When
reinstated.
you are removed? When
But
you
not removed is
removed or dismissed?
not dismissed from service 8/10/1980.
Now, what is it you want? 98 to 92, what is it you are asking?
But 86 to 1992. Well, my services should be counted as continuous by granting increments of that period and to fix my pay accordingly.
When will the increment be granted?
When the order is, I should be.
What is the concept of increment? Please tell us. Out of employment period, you are asking increment. Thanks, you have brought to our notice of this tribunal judgment. We will set aside this order.
86 order.
No,
94.
no. The way which you are asking to be implemented, we will set aside that it is contrary to law.
No, Your Lord, that's covered by the Supreme Court judgment.
No. There can't be an increment. Out of employment period. Increment 1 minute, even if you are paid 365 days in a job, that service should be satisfactory. Then only increment will be given. You can't just pop up the chair and say, I want increment. No, that should be satisfactory service.
Not here. Here, Your Lordship, I'm pleased to see, have been reinstated to the service.
Okay, this petition is filed. Seeking implementation of orders for which administrative tribunal.
One, sir.
This is contrary to law.
No, my lord, it's covered by the Supreme Court latest judgment.
What is it? Without working, you must be given increments.
But when I'm reinstated to service in persons of an order passed by the APA,
So,
Lord, I'm deemed to be in service of that period. I'm deemed to be in service.
okay, we'll clarify that. Don't worry.
Your Lordship,
You are not entitled for increment, sir.
notional increments, Lord, I'm entitled for
No.
it, Your Lordship.
The tribunal is ground OA.
Yes, Your Honor.
The OA is allowed with the direction to the respondents to ensure that the increments are.
Well, a reinstatement is granted. And that particular period from 1986 to 1992 is to be treated as
Okay,
not on
with judgments, okay, different.
for 2023, for 2022, 8SCC, page 378. But I have furnished the copy before your lordship. For this particular issue, what is reinstatement, what is reappointment has been clarified in para number 18, 19 and 20.
Read.
May I read your lordship? Para number 18, your lordship. In our consideration into the legislative bench of the High Court rightly granted relief of leave to the respondent by the impugned judgment and ordered the division bench of the High Court dismissed the appeal of the appellant and directed that the respondent would have to be treated in service from the date of removal to till the date of actual reinstatement in service and would accordingly be entitled to seniority and the right to be considered for promotion, but would not be entitled for the backwards. Next, we find no infirmity in the concurrent findings of the single judge and the bench division of the High Court.
Where is the proposition of increments occurring in the
Seniority and the right. This is one of the what's the next paragraph, your lordship, please to see. There is a difference between reappointment and reinstatement.
increments occurring is here. Increments occurring with your party.
Increments, my lord, when I want to say that,
to law.
Lord, when I'm reading, your lordships are no, your lordships are very aware about this particular subject.
No, no.
When I'm reinstated to the service, no, I'm entitled for it.
What, for what?
I'm entitled for the benefits as if I'm in service from the date of removal till the date of reinstatement.
Increment concept is like this. Merely you are in service does not enable you to earn an increment. It should be satisfactory service.
May I say so, your Honor? Reinstatement means I am deemed to be in service
No.
of that particular
Yes,
period.
you are in service. But that service is a debt service. Because you have not worked.
But even that issue also has been clarified, your Honor. That issue has been clarified by the tribunal. That
Okay, where is your earlier order of tribunal where
Yes.
dismissal order has been set aside?
On the counter,
first, my lord, at the page number not 11, your lordship.
Yes.
But this is the order.
Page
My lord, page number 13, your lordship.
of counter,
No, my lord, along with the great set, my lord.
page number.
13, your lordship, operative portion. There the audit.
Not this one, where dismissal order, where it has been set aside.
Yes, your lordship, but page number 35, your lordship.
I think we are.
35, your lordship, along with the counter.
it's
30,
bottom of the last.
35, bottom, 6 lines, your lordship.
On the ground of discrimination must have, right,
Shows great respect, my lord, now it can't be. They have not filed appeal against it.
in one day only Supreme Court.
Everything, your lordship, can you
Not- This will be treated for duty for back wages.
Back way, not on duty.
And then
No. Back wages, with back wages, I'm not.
One minute. We accordingly,
Order that the petitioner be reinstated in the period of absence from the date of his staying away from the duty in 1982 till the date of his reinstatement be treated as not on duty
No.
for purpose of back wages.
correct,
Not for purpose of back wages, it's very clear.
ఇంక్రిమెంట్ ఎక్కడికి వస్తుందండి యాక్చువల్లీ లేకుండా ఇంక్రిమెంట్ ఎక్కడికి వస్తుంది మీరు వేజ్ తీసుకుంటే ఇంక్రిమెంట్ వస్తుంది వేరే తీసుకోకుంటే ఇంక్రిమెంట్ వస్తుంది
And I clarified about 2013, that not is also.
Right. We say that the judgment cannot be implemented. Correct, if you are filed, right? If petition is filed. Agreed with orders. Agreed with action of respondents in not implementing the orders passed by the administrative tribunal in OA number 1791 of 2010 dated 29th July 2013. Third, Ravi Mohan, senior counsel appearing for the petitioners, and Ramarao, special content for the response. It has been contended by the petitioner that initially was appointed as a police constable in the year 1972, and he has that. And he had to absent himself from duty from 28/4/1982 to 1/5/1982, owing to ill health. And the disciplinary authority has construed the same as a misconduct. And after conducting detailed inquiry and for the proven misconduct in the inquiry, the disciplinary authority has passed orders of dismissal, has dismissed the petitioner as for the proven misconduct, has dismissed the petitioner who had orders dated 8/10/1986. Agreed by the said orders of dismissal, the petitioner had earlier approached the then Andhra Pradesh Administrative Tribunal by filing RP number 3611 of 1989. And the tribunal was pleased to set aside the orders of dismissal and allowed the OA who had orders dated 23/4/1992 and directed it has modified the punishment, no? It has modified it. It was pleased to set orders of, was pleased to modify the orders of dismissal. By orders dated 23/4/1992 to that of reduction in time scale of pay by 2 incremental stages for a period of 2 years with cumulative effect on future increments and pension, and also held that the petitioner is not entitled for back wages. The counsel for the petitioner had contended that in pursuance to orders filed with the administrative tribunal in RP number 3611 of 1989 dated 23/4/1992, the respondents have reinstated the petitioner while proceedings dated 27/1992. However, while reinstating, the respondents have not treated the out of employment period for the purpose of granting increments and for counting for service benefits. In those set of circumstances, petitioner has once again approached the administrative tribunal by filing OA number 1791 of 2010, and the tribunal was pleased to allow the OA
started with 5 minutes, non-implementation of the order, the beginner. In OA number 6 to 19, 2015. And thereafter, my order not regularizing suspension periods of 110 2012 to 2310 2014. And also to regularize the leave period in order. This was the issue in order. And the OA order may not say that page number.
Who is appearing?
20.
Who is appearing? School education, intermediate education. I must just follow the course. Operating person will just take. In view of the above closing the proceedings of content and reinstating the applicant. The applicant is directed to submit a detailed representation ventilating his grievance within a period of 1 week from the date of receipt of a copy of this order. Thereafterwards, the response are directed to pass appropriate orders under Fundamental Rule 54B for regularizing the suspension period of the applicant, taking into consideration the orders of the Honorable High Court, quashing the criminal proceedings and closing CT number so and so within a period of 8 weeks. And also directed to release increments and salary of the applicant for the period she worked as a junior lecturer, who is accordingly disposed of. Very not just on can be implemented.
So fundamental rules do not, the increments are, it's got automatic release of increments.
Correct.
The competent authority and the exam are.
But what is still not said what we have. OA is of 2015. Seven.
This OA is not for. 15 now.
Thank you. Name arrange to step to 17 and the continue.
Actually, that is up to date.
We dispose of
Follow the rules.
particular point. Taking implementation of the orders passed by the administrative tribunal in OA number 6 to
29, super for services 3.
What do you think now?
Maybe there should be like. For that in around addition.
So this, you wanted to recover. What is it you was challenging?
Oh, yeah.
We know that what respondent was challenging before tribunal.
Appointed in the 1976, but then he was promoted in our PPT director. He died in mining faculty township on 31/2011. From papers for 1980, as per the revised rate circular of 1986, that is rupees 1550. In addition,
Number 22 to 2015. That is not quite right. Then how can you not properly filing repetition also will dispense on that ground? Right? He was challenging.
section 21 of
21.
my package will go on 1 and 2, why are allowed by federal proceeding.
It's 22 to 2013. That's what we're asking. 32 Kiranji, page 32. And then Chanpainaka, you have passed this order. How is it maintenance? Page number 33. Chadwandi, subject 7 years.
Question at the 1798, there are.
So you should notice 30 immediately. Amma, notice service Aramir, Chanpaina Victi. These legal orders. Have done? Can you do that? Is it permissible? Me can believe I tell you. Kada me case to. What? So it has to be dismissed. The petition is fine. Tribunal also very staying. Hello. Para 7.
My point, 1 and 2, what is the other proceedings number also dated 22/2013, dated 2011/2012, respectively issued by the second respondent, with a direction to the respondent to fix the pension of the applicant, and husband of the applicant. On the basis of the withdrawn as on the date of their retirement and action, all the retirement benefits including pension.
When is the fixation given to tribunal? You must have filed two petitions, correct? Where is the other petition? What's the name? There is a-
Continue. And then, there was
नहीं, तो मान लीजिए It petition is filed. Read with orders filed with the administrative tribunal. Way number
No. Hari Praveen Kumar, P. Kaveshwar Rao.
Yes. Yes, sir. Ready? Huh? Ready or not?
Yes, ready.
Where is your other friend? Next Tuesday, next.
33 and 34, P.V. Krishnaya, M. Srikanth, Deepika Home.
We'll hear some other friends. 2 weeks.
Yes, yes.
Yes, I've dictated the order, but still you are not agreeing.
Submission, madam, you asked to pass same order which was dictated.
We don't have the dictated.
No,
problem.
only thing, you asked it, observe, that I agree. If I agree, nobody will not make allegations.
Why?
Because this is not entirely not agree.
Don't agree, sir. Who is asking you to agree? You don't agree.
That's why,
That's
that's
right.
one thing I did. Here, only thing not, you asked to pass any order.
Only have a dictation order. I think you have dictated elaborate order.
Dictated. But at the time of.
Yeah. Okay, next Tuesday. Adunke dani santagam pedtam.
Chase without not.
We consider it.
Submit my things. That not the
Correct.
That word that I agree. That the entire contrary to that. That issue is challenging the rule. That tribunal.
You are agreeing for order, but not agreeing to. Mention your name. Wait, you have understood, right?
Yes, that's the case.
We'll search for that order.
Yes.
Post after 2
Much
months. Next.
Close it.
35, C.H. Srinivas, Hari Praveen Kumar.
Yes. Yes, madam, ready? What is the case, sir?
That is the typical level of transfer. I have to Rajasthan, Karnataka, Rajasthan. The government moved complaint from the recommended to transfer station to a far off place. The transfer they
And repeat the same things.
Yes. After the 10/7/2014, that was the time limit, restriction number 789 of OA number.
What is the tribunal do, sir?
Right now, they don't.
Who has filed the case? You have filed.
No, right now, yes, no. Transfer, attending the transfer, that was allowed to the right now.
Then,
Then we have the.
how you are agreed? How you are agreed then?
No, then not against that. So I was relieved from Hyderabad, relieved. Then for minute that I challenged that transfer order. At the time of minute, when the OA, the different moment, the members were not there, there was something subsequently was. That in the response, not to join.
Your way is allowed. How you are, why you are here?
No, minute, that when the interview period is not being regularized. And instruments are not being paid, that is the reason I'm for regulation of that period. And second of implement, that is my grievance.
Okay, recover. What is the rejection order get challenged?
The sanction of middle period. Period, when the date middle is renewed, and when allowed to join in the place middle, after allowing the way.
Where is that speaking order?
The finger middle, page middle, 42. Yes. Why bar the people take to take on metropolitan center and meet Hyderabad and try to win the of difficulty because
Why is it part of increment clause of said rather? You have not worked.
the father leading our success.
Increment is rather.
That merit, they are regularized that
When they are asking for increment,
yes, both
you are not entitled for increment. Huh?
That OA was allowed.
What is that you want? That period to be regulated or increment? Other decided.
Both they have asked for that.
You are not entitled for increment.
That he was relieved from,
Cannot repeat that argument, right?
Huh?
You have understood, right? Like,
that.
you are not entitled for increment, that's what we are telling you. What you are not, you are not entitled.
Increment,
You are not.
they implemented this order after 5 months.
Let it be. Be fortunate.
Not sitting at it is not a fortunate manner. It is scientist, it's sitting.
So what, sir? You are not entitled for increment. Law says you are not entitled. What is, you are not work.
Yes, not.
For various reasons, you have not worked.
I'm not,
And then there is a question of increment.
but the period also not regularized from.
అది అడగండి అది చూస్తాం ఓకే
Period not regularized from 2 years.
వీళ్ళు ఆస్ దట్ మీ లీవ్ ఎంటైటిల్మెంట్ దాని ప్రకారంగా ట్రీట్ చేస్తాం
No, it is not. Whatever the law on 6/11/2000.
whatever it is right next
No, see, that is the reason that the order was different by, I was in military, the deeds will come to the meeting.
cannot be
They are not implemented that order.
they are not implement right then you are not entitled for anything sir.
No, the period when the period is counts, and I will be, at least 1 year increment.
Come back page number 44
Difference.
therefore ఓపెన్ పని చదవండి
Therefore,
అయిపోయింది yes చదవండి పాస్
that's it. Therefore, after due consideration of the facts of the case and relevant rules, it has been decided that the competent authorities that Dr. Rai Babu may apply for kind of leave cure and admissible to him.
అదే చెప్పేసాను అదే you are entitled for leave
Well, entitled for leave cannot be actually cancelled.
you submit an application that period will be regularized correct మీరు
Bureaucracy.
మీరు లీవ్ అప్లై చేయండి రెగ్యులరైజ్ చేస్తారు
Mirror from the date I was transferred mirror till the OA is allowed.
No.
I. Once the date mirror, date of my release from the mirror, from the mirror, the OA is allowed, I continue to apply.
These kind of arguments cannot be accepted, please.
Yeah, submitted.
You are asking regularization with release of salary. మీకు జీతం ఇచ్చి వాళ్ళ మీద లిటిగేషన్ కొట్టడానికి ఇస్తారా జీతం లేదు కోర్టుకు వచ్చి మీరు వచ్చారు కోర్టుకి
Because the transfer of mirror is into transfer. That is illegal, that is unfair.
Real allegation చెప్పండి sir so that everybody also understand why you are transferred.
Why transfer answer come to that.
Why you are transferred.
That answer I come.
Please answer that no.
I'm answering that.
First answer that in answering him.
That's perfect.
Sexual allegations are there.
Without
Sexual harassment allegations are there.
Without there being any inquiry, some committee may have submitted report.
Naturally. But you have not denied that, no? I have not done any చెప్పారా affidavit లో? Let us say on some other ground.
No, that report was said.
On the ground
Yes.
that without something.
Because something mirror this.
But something is there, something is there.
Nothing is there. Even the five criminal case, they may have got clean acquittal.
Naturally, conviction rate in India is 2%. That doesn't mean everybody is the same, right?
I'm saying that.
This kind of argument.
No, once a minute, absolutely there was no charge against me, without there being any charge, without any show cause notice. No charge memo was issued, without notice. When the company failed to conduct some inquiry and submitted report based on that report transfer. So there was no inquiry at all. That plus that they are not really considered by the tribunal, that order they attend the finality and they have not challenged that order also.
Yes, please. Again,
The transfer itself may not be illegal without any reason, only to request me whether the transfer order was given, that allotted consent by the tribunal. But tribunal has certain transfer order, relieving order also. So whether once it's
when you got relieved, 1/7/2017.
no, 2/8/2016. 2/8/2016 are relieved.
Then
Then when the boy was disposed on 3/11/2016,
hello,
disposed of. The earlier boy was disposed of.
saying what?
When they directed the man to consult my representations.
So transfer order was not set aside.
No, the earlier transfer order was not set, then subsequently, that was confirmed in the impugned order, that was challenged.
What is the impugned order?
Original transfer order was challenged subsequent boy.
No, when you were transferred,
Transfer 10/7/2014.
that is subject matter of which OA?
Initially, it was the subject matter of OA 789 of 2014.
789 of 2014.
2014.
Next, that was what happened to that OA?
But that's final disposed of on 3/11/2016.
Saying what?
But directly concern my representative, I have to make fact representation, direct to me concern that representative.
That was rejected.
That was registered on
Date.
23/11, rejected on 23/11/2016.
That again was a subject matter of OA.
Why 1177 of 2016.
11
77 of 2016.
1177 of 2016. When it was allowed?
It was allowed on 6/11/2017.
6/11.
2017.
When posting orders were issued?
3/4/2018.
Why? They have tested that order in High Court.
No, not tested. Thereafter, I made several representations. Ultimately, I quite condemned that they.
Okay, when posting orders are given,
3/4/2018.
Now you are asking 10/7/2014, the date on which you got relief till 3/4/2018, you are asking.
Not for 14. I read on 2/8/2016.
Transfer order is 10/7/2014.
Yes, but then I filed it by the initially there was stay. Subsequently, my boy was dismissed for default. Then I filed petition for registration of boy.
Oh.
That boy was restored.
Oh.
In spite of that, I have relieved.
You are relieved on
2/8/2016. After that, boy was disposed on 3/11/2016.
then challenging this, they have passed this order.
On 23/11/2016.
8th June 2020, they have passed orders rejecting your case for grant of increment, salary and all that. That is the subject matter of this OA.
No, the earlier boy 5 of 2020. Earlier the 5 of 2020. Then the tribunal directed me to consult my representative pass appropriate order that orders are also flexible.
Anyway, first OA 5 of
2020.
for what?
But directed to to regulate the period and for sanction of increments.
So then this order 8 has come. Okay. That is again a subject matter of
This way,
309.
309.
ఒక్క ట్రాన్స్ఫర్ కేసు ఎన్ని కేసు పోయలేసారండి మీరు అన్న మళ్ళీ డిస్మిస్ ఫర్ డిఫాల్ట్ కూడా కదా రిట్ పిటిషన్ ఇస్ ఫైల్డ్
There's a text for the tribunal to determine it. Page 82. Page 82 order allotment taken.
రిట్ పిటిషన్ ఇస్ ఫైల్డ్
Page 82 order.
యు ఆర్ డిస్మిసింగ్ సార్
That's one problem. Page 82 order.
వాట్ డస్ ఇట్ సే
That will be the correction was given to the petitioner. And that will be responsible not easy for reporting at place of place of
Next.
the earlier OA pending. That OA 643 where in the report was challenged, that is pending. This order was passed.
where is that report you have challenged
Report challenged OA 643 of 2016. 643 of 2016.
what happened to the case
That was yellow.
when
When
2016. Twenty-two six 2017. It is error. 22/6, 2017.
22/6.
2017.
The petition is filed. Agreed with the order filed with the Central Administrative Tribunal in OA number 309 of 2020 dated 28th April 2023. Third, CS Srinivas counsel for the petitioner. Vani Reddy counsel for the response. It has been contended with the petitioner that he is working as a principal scientist in the National Research Center on meat. What is meat? Meat is what people eat.
And then
What is this meat? MEAT.
meat that must.
Research on meat. Right? Okay. It has been contended with the petitioner while he was discharging his duties. It was alleged by some women staff that petitioner is sexually harassing them. Based upon such a complaint, the case was referred to preliminary investigation committee and subsequently referred to Women's Complaints Committee. Based upon a report of Women's Complaints Committee, the petitioner was transferred from Hyderabad to Rajasthan. By proceedings dated 10/7/2014. Agreed with the said transfer orders, petitioner has approached the Central Administrative Tribunal by filing OA number 789 of 2014. And the Central Administrative Tribunal was pleased to suspend the transfer orders. However, the said OA was dismissed for default on 17/7/2014. 1/3/2016. As the said OA was dismissed for default, the response have relieved the petitioners from by proceedings dated 2/8/2016 and directed that the petitioner should report to the transferred place. Finally, the petitioner got the OA restored, and finally, the said OA was disposed of by orders dated 3/11/2016, directing the respondents to consider the case of petitioner and pass appropriate orders in accordance with law. Thereafterwards, in pursuance of the orders passed by the Central Administrative Tribunal in OA number 789 of 2014 dated 3/11/2016, the respondents have considered the case of petitioner and rejected the case by proceedings dated 23/11/2016. Agreed by the said rejection orders, the petitioner has once again approached the Central Administrative Tribunal by filing OA number 1177 of 2016, and the tribunal was pleased to set aside the orders of transfer by allowing the OA by the orders dated 6/11/2017. The counsel for the petitioner is further contended. The petitioner has also challenged the report submitted by the Women's Complaints Committee before the Central Administrative Tribunal by filing OA number 643 of 2016. And the Central Administrative Tribunal was pleased to set aside the report by allowing the OA with orders dated 22/6/2017. The counsel for the petitioner had contended in when the response were not treating the service from 2/8/2016. The counsel for the petitioner had contended it when the orders of the tribunal were set aside in OA number, when the orders of transfer were set aside by the tribunal in OA number 1177 of 2016, dated 6/11/2017, the respondents were pleased to. 1 minute again, sir. We're pleased to permit the petitioner to join duty on 3/4/2018. However, the period from date of relief, that is from 2/8/2016 to 3/4/2018, was not being treated as on duty, and the petitioner is entitled for salary from the date of relief till he has rejoined the post, rejoined the work. One for entitled for salary and increments. When the response were not considering the case of petitioner by treating the period from 2/8/2016 as and 2/8/2016 till 3/4/2018 as spent on duty, the petitioner was constrained to approach the Central Administrative Tribunal again by filing OA number 5 of 2020. And the Central Administrative Tribunal was pleased to dispose of the said OA by order dated 6/8/2020 by directing the respondents to consider the case of petitioner and pass a speaking orders. In pursuant to the orders passed by the Central Administrative Tribunal in OA number 5 of 2020 dated 6/8/6/2020. 8/1. The respondents have considered the case of petitioner and rejected his case once again by way of a deleted speaking orders dated 8th June 2020 without appreciating any of the contentions raised with the petitioner. The counsel for the petitioner had contended it. When the transfer order has been set aside by the tribunal in OA number 1177 of 2016, dated 6/11/2017, the response are bound to treat the period from 2/8/2016 till 3/4/2018 as compulsory wait, and the petitioner must be given, and the response must treat the said period as spent on duty, and the response must also pay salary and increments to the petitioner. Therefore, appropriate orders be passed in the petition by directing the respondents by setting aside orders passed with the Central Administrative Tribunal in OA number 309 of 2020 dated 28/4/2023, and also set aside the rejection orders dated 8th June 2020, and further direct the respondents to treat the period from 2/8/2016 to 3/4/2018 It is needless to say, petitioner is permitted to submit a detailed representation enclosing leave applications afresh within a period of 2 weeks. And upon such a representation being received, the respondent shall consider the same and pass appropriate orders in accordance with. Next.
That also may from 9th, this may be treated compulsory waiting for the date of filing.
Cannot be. Sir, 1 minute. Read rules లో ట్రైబ్యునల్ లో కొంచెం పీరియడ్ ఉంటుంది కదా,
Yes, sir.
అది తీసేయాలి కదా.
2 months.
థ్యాంక్ అది అట్లా తీసుకుంటే వెళ్తే ఎన్నో వెళ్తాయి.
2 months, 5 months they delayed.
Naturally. They must have received the certified copy late.
Then I immediately I submitted, 9th itself I submitted copy.
No, you must have submitted a copy, but not certified copy.
Because they are represented by council,
No.
council also had the card,
No.
where council
Certified copy వాళ్ళకి ఎప్పుడు అందింది అక్కడికి కౌంట్ అవుతుంది కదండి.
immediately, simultaneously it will be given.
Government ఎక్కడ ఉంది? Have furnished a certified copy on so and so days.
And then,
When it can be technical, we can be super technical, right?
along with my representative, I submitted copy.
Correct. The Delhi people must receive certified copy, not council here. Correct? Only when certified copy is received, they'll act upon it.
Taking representation, both level at Hyderabad Central and Delhi also.
No, certified copy enforce చేశారా?
Along with copies OA.
OA copy కదండి, certified
But
copy.
this is stamped copy, there are tribunals have to say stamped copy.
No, no,
That is being punished with a stamped copy, but along with the application I submitted.
but they'll depend on their source, not your source, no?
What else? Well, then we have delays on this one.
Why delay? No delay.
No, 6/11 going was allowed. On 9/11, from 9/11, I've been making representations.
Sir, to begin with, you are arguing from the date of relief.
Yes.
When we probed you so much, then you suddenly shifted your gear. No, I'm entitled from 6/11/2017.
Entitled, at least that should be considered from the date of allowing the OA.
No, cannot. Next.
Right, my claim is from 3/11 itself.
That's the reason we permitted you to submit a representation.
But again, once the tribunal is right in rejecting the case, then they will not cancel from that minute this period.
This argument of your 6/11 certified copy, అది చూడండి.
You not answer that. From the date of receipt of the copy minute, that may be cancelled minute, you not be cancelled. Because GOA is allowed on 6/11.
He's a principal scientist, right? One must not be greedy so much, right?
Not greedy minute, support like anything without minute. What's happened for no fault and minute he was victimized.
No,
Only just because of cash.
don't use all those words here.
So that minute, that's why I did not use that word till now.
Let us not precipitate things.
Yes.
Srinivas.
But
Discrimination could be everywhere, but one should not feel like that. One must always think positive.
And even the Deputy also never said that.
Issues are issues in the society, but one must not crib like that. Right?
I did not say in my Deputy also. I did not.
One must face the challenges so that you become strong, right?
So, but this kind of victimization, even after allowing the OA also, we are not keeping in May for 5 months without giving posting
You
order.
can't spend more time on transfer cases. This is too much. No constitutional point is involved, right?
Not constitutional parliament.
Then what is? Enough is enough.
It is.
Somewhere we must stop. Somewhere we must stop, right? We permitted you to submit a representation. You are entitled to say when the certified copy is there, from that date at least implement and అడగండి. అది చూస్తాం, వాళ్ళు చేస్తారు, కన్సిడర్. అదే ఇచ్చాం కదా డైరెక్షన్, కరెక్ట్?
That is not, I think, that.
అన్ని మేము చెప్తే ఇంకా మీరేం చేస్తారు? రిప్రజెంటేషన్ లో మీరు కూడా రాయాలి కదా. థ్యాంక్ యూ.
I write it.
థ్యాంక్ యూ వెరీ మచ్. Do that, right?
36 KR KV Prasad Gadi Praveen Kumar.
Yes. Audit instruct me.
Voting of administrative tribunal. Yes, next week.
Post audit only.
7 P Bhaskar Gadi Praveen Kumar.
Yes.
Send the bodies.
Your 50 solicitor generally here, take notice, why you're worried about it? What is the case? What is the case, madam?
He has filed OA in the year 2015 and OA in the year 2016. OA has been disposed of, directing the respondents to consider with representative.
What happened?
That is been considered and in the year 2017. He has filed again a OA challenging the rejection order in the year.
Please, five counter.
Facing further delay, your lordship, if there is yes. 38, J. Trinadara, Kal Praveen Kumar.
Yes. Competency, charge memo, same case. Traffic,
Yes,
same case, no?
yes,
What happened?
we are saying the
And in the infection, they have also retired. No? On completion of some premature retirement. Now, once you have retired, where is the question of continuing disciplinary proceedings now? 1 minute, madam. The person is already retired. Now, why you want to conduct the disciplinary proceedings now?
decision of the respondents, your
So
lordship.
you want to stop his pension and everything?
She has already applied pension, your lordship. She has also received a 3 months salary of notice period, your lordship. She has applied for pension.
You have also released pension also. If wasn't released pension, why continue disciplinary proceedings? What is the purpose of continuing disciplinary proceedings? In order to punish someone, no? You have allowed him to retire. He is drawing pension. What kind of punishment you will impose?
Increments, your lordship.
Or you increment it to the retire.
Withholding her pension and.
But then why did you release the pension then? You are not able to understand.
Your lordship, she has applied for pension, your lordship. So you have showed a premature retirement.
So, when you are continuing, what? Go on with now.
Pending, your lordship.
అదే అమ్మా కింద కంటిన్యూ అవుతుంది డిసిప్లినరీ క్వశ్చన్స్ చెప్పండి రూల్ 9 లో డిసిప్లినరీ ప్రొసీడింగ్స్ ఆర్ కంటిన్యూయింగ్ అమ్మా దిస్ ఈస్ నాట్ ద ప్లేస్ టు టేక్ ఇన్స్ట్రక్షన్స్ పోస్ట్ ఆపరేటివ్ after 2 weeks we'll consider it.
They conducted inquiry, it's not under rule 9, but what earlier, pursuantly earlier charge sheet, they conducted.
రిటైర్ అయినాక రూల్ 9 వస్తుందండి వేరేది రాదు
Charge sheet is not under rule 9.
Oh, because chart sheet is already issued when you are in service.
Yes.
It will continue under rule 9. What is this is too fundamental, correct? What no, no, right?
No, they don't, what they say, their own circular, what they say, that once an employee.
మీరు ఫస్ట్ రూల్ చూడండి సార్ ప్లీజ్ రిక్వెస్ట్ disciplinary proceedings if charge memo is issued will be continued even after retirement under rule 9. That's the point. Okay.
For only 1 minute, right?
Okay.
They take much time, 1 minute.
No, no.
77 page.
428 ఉంది right.
No, one.
No, 428 ఉంది please. Not today.
Benefit only 1 minute.
420. Thank you. Post after 2 years.
Next week.
39, yes,
Next.
Prasad.
KRKV Prasad, yes. Yes, madam.
In this petition, the petitioner with an acted in common Rama division, which is under the function of first responding.
What do you remarks?
Yes.
Same thing. No?
Chip to argument understand that video will build a valid that he has made objection remarks against the honorable. That's
That should be definite specific. It's so vague. What do you say? Saying what?
There was failure
One allegation, your lordships,
It should be specific, no?
that allegation is specific only.
What is the allegation? Then,
Charge memorandum at 34 to 38.
read 35 to go.
Statement of article of charge made against Sri so and so, so and so. That the said by Harshavardhan matter, ROB Hyderabad involved in making or posting anti-government video. Sri Harshavardhan portrayed the Honorable Prime Minister in an objectionable light and made anti-government statement in a video clip called Party Seal, which was telecast in ABN Andhra
First, because of detailed journalism.
by doing so.
Where is the charge? Rule occurred in the CCA rules. Last time also we can inform you. Charge should be specific, definite, precise. This type of allegation they come. Withdraw this charge sheet, issue a fresh charge sheet. We withdraw this and we will go the case.
Let it be as a court order.
We'll not, what is, okay, we must.
Because I have already advised them to give me written instructions with regard to the same, your lordship, then.
Everybody wants to be safe. He will not get instructions. He will not file counter. You are asking to make it as a court order. Why you must do that? Not able to understand.
I have already.
If they are not following your advice, that's not our problem, no?
Before the tribunal, your lordships, after that.
Thanks.
I had Subhakar Rao.
Yes.
Lordships, kindly, your lordship, this charge memo was issued by the Delhi head office and he has received that the present place of working, your lordship. That is also difficult for me to get the instructions.
What?
Please.
58 Subhakar Rao.
Yes, ma'am.
First April arriving out of land acquisition OP 100/2011, acting by 22 chief additionals, additional chief check, city civil courts, your lordship. Lordship, the land of the appellant was acquired under the award of patent respect of different extents of several premises with and without structures at the.
How much is the delay? How much is the delay?
Delay of 75 days, your lordship.
Where is GP? Who has acquired your land, madam?
Government for road banding, your lordship.
Where is GP? Post after 2 weeks, right? You have what?
Lordship, the compensation amount was deposited in the loan, lordship, during title dispute, your lordship, with respect to the title dispute. Due to the technicalities, it was ordered in favor of the claimant for your lordship. Your lordship,
Section 30, I think it should refer to competent civil court. No?
yes, your lordship, due to technicalities,
Oh.
the order was passed in favor of claimant number 4. Now,
Land acquisition officers should refer, whenever there is a title dispute, he must refer it to the civil court, no? And then what happened? What happened in the civil court?
of the council for the claimants number 1, 2, 3.
Oh.
They have not filed claimant statements, your lordship, due to technicalities.
Then what is technicality? You have not even presented your case, correct?
Your lordship, previously the critical.
But you must claim it, no? Correct, but you must still claim it, no? You are repeating the same thing, then what it should be done now? What kind of stay you are asking?
Lower court, the claimant number 4 has filed an application for withdrawal of the compensation amount, your lordship. On that
How much is the compensation?
18 lakhs.
How many claimants are there? You are one among them.
They may be granted, your lordship. There's a clear title.
Notice has been served on the fourth respondent, madam. Notice has been served on the fourth respondent. We have ordered notice, no, madam. Notice sent, not yet returned. What do you say about that? Proof of service not filed. This is 2020 appeal, no, madam. So 3 years have gone. Could you serve the notice or not? Now here's the question of stay. The fourth respondent must have already walked away with the money. Right or wrong? Yes, Santima, how can we grant anything here? Yeah, clarity is there with us, you also. But there is no clarity in respect of notice, service of notice on the fourth respondent, right? Post after 2 weeks, counsel for the appellant is permitted to take out notice afresh. Cannot be granted the title list. You are obsessed with a clear word, I think. No? Repeating the same thing.
This will be. Respondent needed.
Not on the facts, madam. First, serve notice on the contesting respondent, fourth respondent. Counsel for the appellant is permitted to take out notice afresh on the points post after 2 weeks. Come back. The difficulty is like this. What 3 to 10 are not necessarily parties and null. And you are asking, stay should be granted against fourth respondent. Then why did you say that 3 to 4 are not necessary parties? Clarity. Who is claiming fourth respondent under Vimla Devi Jain, correct?
Lordship, the fourth claimant is the respondent number 1, respondent number 2, your lordship. Fourth claimant in before the trial court is the respondent number 2 here in your lordship. Now she is claiming the compensation amount before the trial court, the lordship. She will file an application for withdrawal of the compensation amount of petition and tax, your lordship.
Who has been adjudicated as the owner, fourth respondent?
Second respondent.
Okay, take out notice. Right. First after 2 weeks.
One side percent ಮುಂದೆ ಬರ ಹೇಳ್ರಿ
Yes, by the Wakala. We have to appellate your loss of the appeal. While the arrest the judgment and degree in lawyers, 278 of 2022, dated 3rd March 2023, in respect of rejection of suit for declaration and perpetual injunction. Not to say earlier, the respondents render and a suit for injunction here withdrawn. Case of the petitioner is the property belongs to the appellant, which is not towards his share in the.
What is the amendment of petition? As though you are arguing first appeal, what is it?
No, I'm only seeking three IAS are there. One is
Argue that. You must confine your argument to only IAS.
IAS, one is permission to issue not to hear by the appellant himself instead of DPA. Because DPA was not
Any objection for the moment? What is it, IA number?
IA to your lot.
IA 2, for the reason stated therein it is ordered, as the council appearing for the response has not opposed the said IA. Next.
And IA 3, your lot, for seeking amendment of the grounds 3 and 8, your lot.
What is it? It be ordered? Yes. IA 3 of 2023, for the reason stated therein it is ordered.
IA
As the response council has no objection for ordering the said IA. Next.
IA 1 is not to alienate the property pending.
First after 2 weeks. IA 1. Right, next.
What is the thing? Property is alienated.
Right, next. Your suit is dismissed. Your suit is dismissed.
No, indeed.
No, no.
Round your lots, division bench has
Okay, all right, after 2 weeks. Next.
One submission is earlier in the same matter, the legal bench of this honorable court has passed an order not to alienate.
Okay, you don't request here.
That was prior to disposal of the suit, your lordship. At least your lordship.
No, cannot be.
42 Shintalapudi Lakshmi Kumari Ashok Vipala.
And this is Ben Madhav for appellate, your lordship.
You go and find Wakala in connection with it.
That is there, your lordship.
Then go and pursue the registry. Next.
Tomorrow.
Only tomorrow or option.
No, tomorrow is not, I need time because I have bad of action. Maybe I have to keep him out. They've been asking for time and die every time.
Next Wednesday.
Next.
Next. Madam, you should not make senior counsel wait. If you do not inform them, no? These are basic courtesies, whatever it is. Senior counsels are waiting since morning.
We are not paid here. Inform and then there are the, and then we are.
Niceties of probation should be maintained, madam. The respect should be given to senior counsel.
But we try to contact them on phone also. But.
43 and 44 CA Janardhan Reddy, Mohammed Nawaz Haider Ali, H. Sudhakar Rao.
Yes. This was declared in the plaintiff in the lower court, the owner of the property and what in yes, someone. In a state. What's up to say, that's
We can't adjourn any case on day-to-day basis. 2 weeks, yes, 2 weeks after from date we will.
Yes, 66.
First after 4 weeks.
And after.
91, how it is covered?
Whether next promotional hierarchy.
But we were here, other side, restrictions are allowed.
Yes.
We, 90,
51 you know.
who is your other side? The order cannot be passed, next year it is passed in his presence. So. Tomorrow, 91 tomorrow, army schools, what do you want? Bring some.
16 months. Okay.